be permitted to mention one matter. Well, the matter was already mentioned on 1st of September 25 under the heading to be mentioned. So that, my lord, the affidavits can be filed before your lordship. My lord, this is a long pending matter. I have a pressure upon the department, my lord. I know your lordship is listing the matters under the hearing after vacation. My lord, it can be after vacation. No, my lord.
Then what is the urgency?
Well, urgency is I have to file the affidavit. Affidavit is affirmed long back.
File in the department.
No, here, my lord, the system is otherwise, my lord. Unlike other courts, as well, I'm grateful to your lordship, including the Honorable Supreme Court, affidavits are filed before the department and concerned registry. But here, my lord,
Yes,
I have already served notice.
don't request for upgradation, sir. I cannot deprive anybody.
My lord, I am mentioning one.
Motion matters, just hand over the slip. I will not upgrade any matter.
One application matter.
Wait, motion matters, just hand over the slip.
Restoration application, my lord, kindly says restoration.
After vacation.
Oh, my lord, very
What is the urgency?
urgency.
If you have don't urgency to come at
My
the
lord,
time of
my lord,
call, sir,
very,
then there is no urgency
no,
for
no, no,
restoration.
my lord, very urgent.
After vacation, sorry.
Kindly, my lord,
No, sir.
application, my lord, restoration.
No, sir, not now.
Service completed, my
Very
lord.
good. Remaining good. After vacation.
My lord, I am mentioning one
Wait,
matter.
sir, wait one after
I
another.
have mentioned the matter before your lordship on 28th. My lord. Your lordship was pleased to direct me to file the matter in the department. My lord. I have filed it, my lord, fixing the date of 8th, my lord. My lord, relating to acquisition of land, my lord. Forcibly, my lord.
After vacation.
My lord, kindly consider.
No upgradation.
No, this
For your case, I cannot deprive another person.
my
Very
lord,
sorry.
This is
Mr. Shah,
my lord, this is not.
no upgradation.
This
Yes.
is not upgradation, my lord.
Yes, give.
My lord, this is not upgradation. I have filed it.
For your satisfaction, I can take the slip, but I can assure you that if you force me to take the slip, I will list the matter in the month of December.
My lord,
Yes.
affidavit in opposition was to be filed by 10th of July. It's a department, it's Navy is the department.
To be mentioned in
It's a-
Yasun, they can.
I'm mentioning notice it.
My lord, one matter I am mentioning before you, my lord. The mood
So don't request for upgradation. I am requesting the members of the
uh,
party.
my lord, my client's age as per voter list and school certificate, there are difference. They, whether your lordship will decide whether the voter list is
What is
absolutely,
the urgency, sir? It will be taken up.
my lord, I am mentioning, my
taken up.
lord, one
No, sorry.
2008 matter, my lord.
Hearing matter.
Uh,
Hearing matter, sir, I am not taking. There is a clear indication.
My lord,
Mention after
he is suffering, very suffering, my lord.
मुश्किल है.
My lord, it is only take 10 minutes only. I am
For in 10 minutes, I can take.
served upon the other side.
নিয়ে নিন month after vacation দেবো কিছু দেবে না নিয়ে নিন.
Lordship, may I be permitted to mention this matter for inclusion in the list, Lordship?
লিখে রাখুন after vacation hearing matter. Yes.
Lordship, inclusion for the list, Lordship. Lordship,
Yes, give it.
filed in the
Deeply obliged by.
Motion matter.
Lordship.
Give.
Deeply obliged.
Any other mentioning? Call the list.
Or I am approved for the petition, my lord.
I'm for the respondent.
Why it is under the heading to be mentioned?
My lord, non-prosecution, my lord.
দেখি ওটা দিন ওইটা দিন. You are Mr. Maiti?
Yes, my lord.
At the time of hearing, Mr. Maiti, learned advocate appearing Same matter, same date. 1 to dispose of. Call the next matter.
Great.
Correction.
I am for
What is the
petition.
name? Have you indicated?
Yes,
sir?
yes, yes, brother.
Thank you, sir.
Paragraph 4, there is two identical matters. Your lordship has been passed in 1, 2, 3.
Why your judge made so much mistake? Why your judge may make so much mistake?
No.
Huh?
No, no, no.
Don't come to this judge. Very bad
No,
judge.
no, no, no.
এই দাও গো ফাইলটা দাও। কি হলো পাওয়া যাচ্ছে না? বাবু সকাল থেকে একটু পারপ্লেক্সড আছেন দেখছি। দেখি উনি কি দিচ্ছেন একটা দিন, উনি যেটা দিয়েছেন।
হ্যাঁ, আমি দিলাম তো।
আরে দিন না, উনি ইন্ডিকেশন হ্যাভ ইউ ইন্ডিকেটেড?
Yes, 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 blood.
আরে দাও।
না না এই মাত্র দিলাম তো, হ্যান্ড ওভার করলাম। That's
এনিওয়ে
my
টেল মি দে আর মিসপ্লেসড ইট। Which order is required to be rectified, sir?
blood. In paragraph 4, blood, kindly see
Yes.
the respondent number 8 stroke authority in WPA number 12355 instead and in place of 12355 it should be 16974.
Oh.
There are two identical matters.
One-
This has been passed.
So in
the order.
paragraph 2 there are two figures are required to be decided.
Now only one figure, blood, 16974. Instead of 12355, it should be blood 16974
In the first line,
in the first line.
but in the last line it is all
Yes,
right.
it will be same. Is directed to abide
Oh,
by
I'm
the
sorry.
direction
Yes.
as passed by in
Sure.
WPN.
The instant matter is listed today.
Great.
Well, this is the matter where I mentioned yesterday we have to give the exception to the report. Well, because there's no interim order in my favor. The reason why the issue is they have executed a lease deed in my favor. First allotment, then payment, then lease deed, then mutation, but I'm not getting possession. So in their report, they do not deny the allotment. They do not deny the draft deed being forwarded to me. They don't deny the payment made by us, mutation, but simplicity they deny the
File it.
I deny the
Where is your
execution.
exception?
Lord.
exception. Lordship, I need some time. That's why.
Oh, yes. আসুন। Mr. Mitro, এবার অয়ন চ্যাটার্জি হয়ে গেল কেন? তো অয়ন ব্যানার্জি হবে, আবার নাম ফাম সব উল্টো পাল্টা লেখেন। কিন্তু অয়ন চ্যাটার্জি হবে কেন? ব্যানার্জি হবে তো। Why is Mr. Banerjee? Mr. Banerjee is appearing,
Yes,
no?
yes.
Why is Mr. Banerjee? Can it be taken up now? Or I'll keep it pass over. What is your instruction?
Junior assigned by the state, my lord, he was.
Very good. I'm keeping
Yeah.
pass over for some time. Wait for some
My
time.
lord, at 12, my lord.
Wait for some time. He may come.
We also have the same difficulty which Mr. Banerjee had.
Very good. Then 12 o'clock. 12 o'clock.
12. Yes.
Please inform Mr. Banerjee.
Yes.
ওটাকে একটু খেয়াল রাখবেন, ওটা অয়ন মিস্টার অয়ন চ্যাটার্জি হয়ে গেছে আগে ধীরে ধীরে। Yes, yes. Next.
Number 7.
7 who is appearing?
My lord, I'm for the railway authority, my lord.
I'm appearing for the state respondent.
Yes, yes.
Okay, তাহলে
Wait,
six
wait,
টা-
wait. Mr.
six টা-
Banerjee, please come. Item number 6.
I'm sorry, my lord.
No, it's all right. একটা লাইন লিখে রাখুন তো। On perusal of the previous place your case, sir.
Now, my lord, the second round of litigation. Now, my
Yes.
lord, Justice, kindly come to page 59.
Page 59
Yes. Annexure P3
of the writ petition.
of the litigation. A particular sand block was awarded in favor of my lord, the petitioner by award of contract dated November 10, 2017. Now, Lordship, kindly skip over my next page,
60.
60. Serial number 40. 14. Now, the third column, Kaksha / Bushudha, have you Lordship? Kaksha / Bushudha / 4787. My lord, this indicates, my lord, the particular dark number. P part. No, my lord, this was, my lord, Lordship, kindly come to the next page. Awarded contract 2.5 crores. 1/3, my lord, 83
Page number, page number.
page, my lord, 62.
Yes.
83 lakhs odd, my lord, was paid on 4th January 2016.
Towards
My lord, 1/3 of the royalty, my lord.
towards 1/3 of the royalty.
2 crore 50, my lord, was the total value of the my lord contract.
Very good. Then what happened, sir?
Now, my lord, we found, my lord, the sand block, my lord, situated in such a place where, my lord, bridge, motorable bridge from Ilambazar to Bolpur was there. That apart, my lord, high tension WBSC DCL tower was also there. Could not be, my lord, processed. Now, my lord, page 63. We made an application before, my lord, the district land and land reforms officer and additional district magistrate. My lord, 64, my lord, the type page. 64.
It is on the riverbed of Ajoy.
Yes, Ajay. Now, my lord, 12 June 2018, the Deputy District Land and Land Reforms Officer directed the Block Land and Land Reforms Officer, Kaksha, Paschim Bardhaman, to make an inquiry and send a report. My lord, last two line.
Page number 62.
64. My lord, type
64, I'm sorry.
type copy.
So what is your letter?
I
Where you have difficulty?
No, that, my lord, in earlier round of litigation, my lord.
Very good, very good, very good.
Yes. Physical inquiry regarding availability of the sand with respect to the sand block Kaksha Bosuda 4787P. Last two line. He is requested to cause field inquiry and send a report to this end regarding availability of the sand. My lord, this was not taken care of by the concerned block land and land reforms officer.
No, Mr. Chattopadhyay.
Yes.
What is your grievance
Yes.
after obtaining the work order?
My lord, this could not be processed, my lord, due to, my lord, the sand block is just beneath, my lord, the bridge, as well as, my lord, the high tension line. My lord, if, my lord, sand
Bridge means the Panagora Nilambai.
yes, and, my lord, very adjacent to the bridge, my lord, there is high tension line of WBSC DCL. Once it is excavated, my lord, there is every possibility of, my lord, endangerment entire pillar. So, my lord, this question was raised. This was taken care of, and Deputy DLLRO, my lord, directed BLLRO to cause an inquiry and send a report. This was not taken care of. Now, my lord, we approached the honorable court, my lord. Lordships, kindly come to page 70.
70.
70.
Yes.
My lord, everything, my lord, was dealt with. Inner page 3, page 72. My lord, the ordering portion.
Yes.
My lord, last part 2 paragraphs. Be that as it may, after considering the rival contention of the parties and upon perusal of the materials on record, the respondent number 4, upon issuing a prior notice to the petitioner, is directed to conduct a physical inspection of the tendered site, for which the petitioner submitted its offer and shall prepare a detailed inspection report and forward the same to the petitioner and the respondent number 5.
Yes.
The exercise shall be carried out by the respondent number 4 positively within a period of 4 weeks from the date of communication of this order. There are 3 parts of this order. Prior inspection to be given to the petitioner.
Notice.
Prior notice to the inspection of the inspection.
Prior notice, physical inspection and preparation of the report.
And that is to be intimated to the petitioner prior to the date of hearing. And, my lord, the last paragraph, after receiving the report from the respondent number 4, page 72.
Yes.
The respondent number 5, upon issuing a prior hearing notice at least 7 days to the petitioner and the respondent number 4, and after granting them opportunity of hearing in presence of all the necessary land records, shall dispose of the issue by passing a reasoned order in accordance with law. Now, my lord, lordships, kindly come to page 75.
75.
Neither we are issued, my lord, the intimated, my lord, the prior inspection notice, nor we are able to be present at the time of inspection. Straightway, my lord, ADM and DLLRO issued notice on 16th April 25 with a view to comply the solemn order passed by the Honorable Calcutta High Court under reference. Please take notice the hearing will be held on 24th April 2022 at 1 p.m.
Notice no served.
Notice not.
Regarding inspection, no notice served.
No, no.
Just a minute, sir. Yes, then
My lord, we, my lord, appeared before the ADM and DLLRO, intimated him the difficulties. Now, it was concluded, lordship kindly, it was 1 p.m. my lord, the hearing date, time of hearing was fixed. It was concluded by 1:30, we left out. Now, next page 76. Have you lordship got?
yes.
This is an email communication from the BL and LRO Kaksha, lordship, at the top mind or left.
Hmm.
BL LRO Kaksha to the petitioner as well as me because I attended. Right hand column, my lord, April 24 at 3:37 p.m. Same date when the date of hearing. Please go through the attached files and oblige. This is the first time when, my lord, inspection report, though it was conducted ex parte, was forwarded. Now kindly come to next page. 24th April, it was concluded by 1:30. It was forwarded at 3:37 p.m.
Yes.
Now, my lord, next page 77.
Hmm.
Have you also got page 77? Now, my lord, this is the report which was attached with the mail. Memo number. Memo number is very vital. Also, kindly take note. Memo number 474. Dated 23rd April 2025.
Hmm.
In compliance with the above mentioned subject, the physical inspection report of sand block was conducted on 4th March 25 at the tender site, bearing number Kaksha, have you also got? Kaksha Bosuda /4785 with within bracket P 1255 within bracket P. Now I will, my lord, trouble your lordship, my lord, to come back, my lord, page 60 once.
60.
60. I already, my lord, placed it. Serial number 14. Lordship, third column.
4787. 4785.
85.
Oh, it's for 4787.
87. Inspection was conducted, different plot. Now, the next page. This was also an attachment. Next page. Yes, that was also an attachment of the memo. Sixth column. Plot number.
785.
So, direction was given something. Some other block was inspected. I do not know whether it is at all inspected because no notice was served. Now, your lordships kindly come to the order under challenge at page 108.
In portion is 109.
109.
Yes.
I will refer my third paragraph.
Yes, sir.
In terms of the solemn order dated 10th February 2025, passed by Honorable Calcutta High Court in such and such, Kaksha has caused a physical inspection of the tender site in question and has sent the report thereof to this end via office memo 327. Now, I will again, my lord, request you, lordship, my lord, to come back to page 77. Have you lordship got?
Wait for some time.
Here, my lord, memo number 474, something different memo was forwarded and some other memo has been forwarded to the ADM and DLRO by the DLLR.
Then what happens, sir?
No, my lord, thereafter, my lord, in a detailed order, my lord, yes, my lord, dates are also different. My lord, detailed order, my lord, ADM and DLR, my lord, rejected my contention. So, my lord, my first contention is that the order which was passed, wherein strict adherence was directed, was not done. Inspection was done, if at all any, without my presence. And my lord, inspection was done, if at all any, in respect of some other plot, which was not even allotted to me.
So what they have said in their report?
They have, my lord, annexed one receipt indicating that 2 points were taken, which can be, my lord, page 14 of their reply.
Report.
Page
number 14. Yes.
This is, my lord, a registered letter addressed, my lord, appearing to be in the name of petitioner, but whether it has at all been served and reached the petitioner is not substantiated by any document. And I have categorically said I have not received any document. And even assuming, my lord, the notice was served. Evidently, my lord, the report which was directed to be
Notice was served.
even assuming but not admitting, this was served. My lord, the report which was directed to be forwarded 7 days prior to the date of hearing was served after the conclusion of the hearing. It was concluded at 1:30. I have specifically pleaded in my petition, and it was by mail. I reached the email at 3:47. But I have not received any notice. I was not present. Had it been, my lord, I have been pursuing the matter for last 7 years. I could have.
So, according to you, for the sake of argument, if it is accepted that the notice was served, but the inspection was conducted at different site, violating the order of the
Absolutely.
coordinate bench.
Order itself is absolutely illegal, my lord. Let an inspection, my lord, be done in our presence.
Mr. Banerjee.
Pass an order.
There are 2 points. One is of notice. The other is that inspection in respect of another plot, 4787, and inspection in respect of 4785. Now, regarding notice, I have annexed the notice along with the postal receipt. There will be presumption of service. Now, if not, he is disputing this notice, then kindly give us some time. We will inquire from the postal authority. But if not, it is found that it was served upon him, then he shall be put to cost. If he takes the risk, I can request your lordship to give us some time if he is pursuing that point, because we have annexed the postal track report, postal receipt. So that's up to him. If he challenges that, then I'll request for some time to ascertain. The other point regarding another plot number, because that is his grievance, that another plot number, kindly comes to page allotment. Yes, shown me the allotments in respect of 4787, page 60
Of the report or petition.
of the petition, page 60. He has shown me that he has been allotted 4787. Aniruddha Banerjee. Finally goes 2 items before that, item serial number 12. Same Mauja Milord, Kanksha Basuda 4785 was also allotted to him. So it is not correct that 4787 only is allotted. Number 1. So they are avoiding 4787 and pointing avoiding 4785. And as it not, only 4787 has been allotted. So 4785 was also allotted. Now kindly comes to the application.
No, in the previous round of litigation, which one is the disputed
In
plot?
the petition, in the order, plot number is not mentioned. If your lordship kindly comes to page 68, which is the application.
In the previous petition?
Yes, it is the application for shifting, 27th April. Kindly come to page 69, last paragraph. In view of the above,
Just a minute, sir.
'69, 68, third paragraph, and 69, last paragraph. Last but one.
Page number, page number
68 is the application. 68, third paragraph.
69 is the relevant page.
68, third paragraph is relevant because he is mentioning 4785.
Just a minute, sir. Yes.
And 69, last but one paragraph. In view of the above.
68. This says about 4785.
My lord. In view of the above, I would implore upon your good self to shift the leasehold area from the allotted sand block, which will be so and so 4785, to another block. So his prayer was for 4785. Inspection conducted for 4785.
In page number 69, which paragraph is?
Last but one, my lord. In view of the above. It starts with the words in view of the above.
To shift this handle area
4785.
from 4785.
So his prayer was for 4785. And hearing was given for 4785. Inspection was also done for 4785. So the allegation that prayed for one block and another block inspected is not correct, my lord. And regarding the service of notice, my lord, if he is seriously disputing that, then kindly give us some time. Because I have annexed, my lord, the postal presumption is that it has been served. Presumption of good service is always there unless the contrary is proved by them.
So in 4785, that is the disputed plot.
No. Application made at page 68, 69.
No.
No, which is why I'm asking for the application. What is your application?
Previous application is not here, not annexed.
No. My lord, I have just made, permit me. Maybe
Where is your pleading to that effect? That in respect of
kindly come to page 61. That there is a mistake, my lord, done by the authorities. Page 60. Page 60, my lord, serial number 11 and serial number 12. Amount is something different. I paid 1/3 of 2 crore 50. That is 83 lakhs. So when I paid 83 lakhs, it corresponds to 4787.
No, what is the document? According to you, which shows that you have difficulty with regard to 4787. What is that document?
Application is for 4785. So why should we consider for 4785?
Page 63. Page 63. Page 60, page 64, my lord, type copy. There, my lord, when my lord, Deputy DLLRO, my lord, directed BLRO to cause an inspect, that is 4787. How, my lord, 4785 can come into play? This was the cause of action of the earlier writ petition.
Where is the application?
Non-consideration.
Not annexed. Previous treaty is also not disclosed. Whether at all he is asking for shifting or not, that is not clear from
No, sir. Page number 63/7, that you have directed the
inspection of 4787.
BLRO
Yes.
to cause inspection in respect of 4787.
Yes. So for what? Whether there is a prayer for shifting. Unless there is a prayer for shifting, we cannot initiate a proceeding for shifting. Let him show the application for shifting.
So what is your application?
Application, my lord, this application, which was my lord, the cause of action for the letter dated 12 June was misplaced. That was pleaded. Supplementary affidavit to that effect, my lord, was given in the earlier round of litigation. That was exactly the question was taken. Honorable Court, my lord, coordinate directed. It is your record. You produce it. Could not be produced. Then Honorable Court directed me to file a supplementary affidavit. That was given on the basis of, my lord, it was disposed.
So there is there is a mismatch in page number 63 and 68.
No, 60, my lord, first paragraph. 68, first paragraph. Not only 4787, 4785, 4787 were also mentioned. First paragraph. My lord, fifth line. Lord, kindly see. When I made representation, there, my lord, 4787 also mentioned. And my lord,
Read the paragraph.
Yes. I obtained sand mining lease to participate in an e-auction floated by the government of West Bengal in respect of the sand block such and such over plot number 4787.
So there, in the first paragraph, there is no whisper about dispute. Second paragraph,
Yes,
thereafter
third
on my
paragraph.
visit, I noticed that one of these sand
Thereafter,
block,
on my visit,
4787 is completely submerged under water, not available in the mineral
and
sand.
while high tension may collapse. Ilam Bazar bridge, that is mentioned there on the third paragraph. May I place my the paragraph?
The only application available is in respect of 4785. If he makes an application for 4787, it shall be considered.
And
But as on date, there is no
another-
application available on record in respect of
order dated 10th
4787.
February
Come to page number 8,
8.
paragraph 12. Paragraph 12.
Yes,
You have grievance with 4787.
87.
Then why are you mismatching with 4785?
4785, my lord, there was a typographical error caused in the earlier round of litigation, or the writ petition was drafted by some other advocate, my lord. It was a change brief. 4785, and my lord, kindly see the order. Order, my lord, passed in the earlier round of litigation. At page 70. Page 70.
Take down. Dhar is here.
Yes,
Mr. Dhar, in yesterday's matter,
Malord.
I have directed, rather I have requested you to communicate the server copy of this order to the principal secretaries of both the departments, land and land revenue and panchayat and rural development.
I have already had a word.
7. I've got 6, sorry.
Call the next matter.
6, sir. 6, 7.
হয়ে গেল।
7 আমাদের 7.
Sixটা হয়েছে, 6 হয়েছে।
7.
7, call 7.
আমি দেখেছি।
কি হলো? What happened? File miss. কি করে গুছিয়ে রাখুন।
Last occasion, Malord, yesterday, Malord, I filed
Sir,
my
give me a second, sir. Liberty is given to the representative to file exceptions to the report of the respondent state. You
yesterday.
have filed today.
Yesterday I filed, Malord. I think, Malord, it has not been gone down, Malord, in the order.
It has not been noted.
No.
It was
Yesterday only
filed
your
yesterday.
lordship- Yes, I have filed yesterday, my lord, because only yesterday your lordship, my lord, only adjourned this matter. But I have, my lord, submitted this one, the composite.
But no order was passed. Then I have to record the order. Yes. Is there any can?
No,
No can. Can disposed of, no?
no, this was.
One report is filed on behalf of the respondent numbers 1 to 6, and then another report is of the state respondent. And you have filed a composite
Composite. Yes.
exception. Very good. Give me a second, sir.
Documents are, my lord, elected.
Sir, give me a second. So has it been heard?
Yes, my lord, your lordship heard this matter and granted, my lord, interim order. That interim order is subsisting, my lord.
When I pass the interim order, sir?
My lord has heard the similar matter and passed an order in respect of.
Let me argue, then you.
No, no. My
So,
lord
No,
has
no,
can-
when I heard the pass the interim order, last day of interim order has passed earlier. With regard to the position till the last day of August, yes. So it was passed on 8/7/2025.
Yes.
Yes.
Very good. Place your case, sir.
Yes. My case is that, my lord, the mother of the petitioner was, my lord, owner of a plot of land, my lord, because, my lord, she died. My lord, owner of a plot of land that, my lord, corresponding to, my lord, RS number, my lord, 2246
Yes.
of Mauja Dulia. It is at Howrah, my lord.
Duilla.
Dulia. No, not Dulia. Dulia is the different. Dulia. Pipe cutter, 19 chitaks and 12 square feet. Kindly record it. It is very relevant. Conversion করেছিলাম না? Conversion. Which is equivalent to, my lord, 70.618, my lord.
5 cutter, 19 chitaks, 12 square feet.
This is equivalent to, my lord, 17.618.
17.618
618 decimal of land, my lord.
acre.
Sorry, acre of land. Acre.
Is situated in RS plot number 2246.
2246.
In Mouja Duilla, under PS Sagrail. Yes. Then what happened, sir?
Subsequently, my lord, during my lord her lifetime, my lord, he obtained a section plan from the Jila Parishad and my lord constructed a building there. Suddenly, my lord, railway authority, my lord, pasted issued a stop work notice on the ground that it was acquired by the railway authority. My lord, I have inquired. I have, my lord, found only my land was published under section 4 of the Land Acquisition Act notification. But when the notice under section 6 was published, the land of the petitioner was excluded.
Excluded.
Excluded, that is not in the list. Thereafter, no notification. Even, my lord, I will place the, my lord, document also. State authority also says that is only with regard to section 4 notification.
No, section 6 notice excluded your land.
Yes, yes. That is not
Your mother's land, rather.
yes, motherlands.
Very good.
Subsequently, in the 2023, my lord, railway authority, without giving any intimation to us, my lord, recorded their name in the land records, my lord, revenue records. Challenging that, my lord, one way is pending before the, my lord,
Tribunal.
tribunal. No, or before the authority, BLRO.
Very good.
Now, challenging that stop work notice, I came before this honorable court. This honorable court relegated this matter to the railway authority to decide it, whether the land has been acquired or not. My lord, that is the impugn order which has been, my lord, challenged before your lordship, and your lordship will find that is appearing page 181.
Page number 181.
181. 182, sorry, my lord, 182. 182.
Impugn order is page at number 182.
The
Yes.
long order, may I read, my lord? It's a long order. Before that, my lord, my lord, to submit that, my lord, without any notification, the authority said it is the land of the petitioner. There is no notification.
Mr. Dhar, I believe it will take some time. The other matters will
Yes,
get
my lord,
delayed.
because
There is an injunction order passed by my.
That is
that
the
will continue.
That is the
That
difficulty.
will continue. Then, my lord, I am
I'll
ready.
show. I'll show.
I am ready.
It would take
very good, very good.
developmental work.
Very
is
good, very good, very
installed.
good. Very
My
good.
lord, may I inform this court an identical
Order my lord has already dealt with. My lord has passed, and my lord has put in heavy cost.
6 lakhs.
Yes, my lord. And this issue has been decided, my lord.
So that has been challenged in an
That has
appeal.
been challenged and appeal is pending.
Appeal is
I am aware that appeal
I
is
have
pending.
to know that, my lord, judgment, my lord, where your
Very good, sir. You place your case.
whether
Place,
it is, my lord,
place,
similar to
place
the
your
back or
case.
not.
Place your case.
My lord, may I take a leave for that appeal itself, my lord? It is to be appear now in court number 10, my lord.
Very good.
I'm grateful, my lord.
No, I am here. My lord, I'll
I'll adopt the argument of the state.
Very good. Place your case. Place your-
Yes. Now, my lord, kindly read out, my lord, that I am the divisional engineer east of the Southeastern Railway, Kharagpur, that is number 4 of the WPN.
read from here. Read from here. Last
Which-
paragraph. That I suitably examine.
Yes.
Page number 182, last paragraph.
My
Sir.
lord, yes. That I suitably examined the representation dated 14/3/2024, being annexure P10 in the WPA number 11409 of 2024, with all of your further representation letter, etc. Your written notes of argument dated 29/2024, letter dated 3/4/2024, and 25/4/2025, including all the documents submitted therein, and I also suitably examined all the available office record. Kindly record it, madam. Office record, paper, correspondence, documents put up to 28 April 2025, including the statement with all concerned gazette notification That is also very relevant, my lord. Gazette notification showing all the surrounding acquired CS DAG numbers of CS DAG number 2246, GL number 35, Mauja Dulia, Shakrail, Haura under section 6 of the Land Acquisition Act 1894. That is surrounding area, not, my lord, in respect of my land. B, copies of the specimen gazette notification indicating showing the norms of any transfer of the government lands for cancellation, relinquishment, transfer, modification, erratum, etc. for the several measures as published through various gazette notification, including one erratum published through gazette notification dated 6/12/1963 against the previous declaration under the gazette notification number 17004. LA dated 16/10/1961 for the self-same Mauja of Dulia, and the railways Khotian number 9175 for Mauja Dulia, including CSRS plot number 2246 corresponding to LR plot number 2278. In full was issued in favor of the railway by the government of West Bengal. So there is no other notification regarding my lord. He says, my lord, only notification of section 6 in respect of
No, one erratum is there.
erratum. No, he says the specimen copy of the erratum. That I will show, ma. That they have,
Yes, very good.
they have annexed, my lord. They have annexed, my lord. I will take your lordship in that, my lord, also. That during the personal hearing, you submitted that your land was not acquired and you are in possession of that land. You further submit that the land being CS RS DAG number 2246 corresponding to LR DAG number 2278 of Mauja Dulia, GL number 35 PS Sakrai, District Howrah was notified via the Calcutta Gazette notification number 13690 LA dated 22nd August 1961 under section 4 of the Land Acquisition Act, but not finally acquired, and submits the above mentioned documents in favor of your claims. Per contra, railway officials submit that the concerned CSRS DAG number 2246 corresponding to LR DAG number 2278 has been duly acquired. There is no document. The petitioner has in unlawful possession of the same, and the said plot on the DAG of land is found in the records by the name of Southeastern Railway as per the records of the government of West Bengal, and further submit that there is no authentic documents evident has been found in the records that the CSRS plot number 2246 the LR plot was cancelled, relinquished, transferred, modified erratum in favor of the petitioner. That during the hearing, you finally submit that CS plot number 2246 corresponding to LR plot number 2278 at Mauja Dulia Police Station Sakrail, District Howrah was notified for acquisition but not finally acquired, but you failed to submit any authentic document and constant gazette notification for the same, which is beyond the norms of any transfer of the government funds for any cancellation, relinquishment, transfer, modification, item, etc. Further, you are in possession at the said CSRS DAG number 2246 corresponding to LR DAG number 2278 of Mauja Dulia by the power of sale deeds of your mother by deed number 31069538 as registered on 9/4/2012 and 27/10/2014 respectively after the acquisition. So your existence over the said government land CS DAG number corresponding to LR DAG number 227 Mauja Dulia is not authorized, as the property was acquired by the government long before for a public purpose. So any subsequent sale or registration by the former owner would not be enforceable, as the government is now the rightful owner of the concerned DAG or plot number in question, and without proper gazette notification, authentic documents, no government land has been transferred, acquired, added, altered, relinquished by the competent authority for any public purpose. Further, I did not find any proper authentication, valid gazette notification, and or authenticate legal documents against your claims submission. Per contra, it is found that the concerned CSR corresponding LR 2278 in full was recorded in favor of the railway by the government of West Bengal. That is the order. After finally gives us 15 days time to vacate the premises.
Yes.
So, Male, admittedly, there is only one notification under section 4. There is no notification in respect of the land of the petitioner under section 6. Nowhere it is stated. that the land of the petitioner was published.
Sorry?
Land of the petitioner is, my lord, included in, my lord, section 4, not in, my lord, in the notification under section 6 of the Land Acquisition Act. No document.
But come to paragraph, third paragraph of page number 183.
That during hearing,
Yes.
you finally submit CS plot number 2246 corresponding to LR 2278 of Mauja Police Station Chakrail was notified for acquisition, but no, finally
Not finally acquired.
acquired.
But you failed to submit any authentic document or concerned gazette notification for the same, which is beyond the norms of the transfer.
He says that because I have not produced any document.
Huh.
So if it is not in the, my lord, section 6 notification, how can I produce? Why? Because, my lord, section 6, your lordship knows that, my lord, before the, my lord, no action can be taken thereafter if section 6 is not published.
What is the document of title?
Title date.
What is your document of
Annexure
title?
A, my lord.
Huh?
Annexure A.
Page number?
It starts from page 30, my lord.
No, property belongs to whom? Susila Devi.
Yes, mother of the writ petitioner.
So what is the document of title of Susila Devi?
This is a, my lord. This is a title deed. Thereafter, my lord, she also, my lord, recorded his name in the, my lord, LR record.
Try
That
to understand. Who is the writ petitioner here?
the son of the, my lord.
Neeraj Kumar.
Yes.
Then
Son of the.
how Susila become the owner?
My lord, Neeraj Kumar is the, my lord, son of the Sushila Devi.
I understand, sir.
Yes.
Your petition starts with that your petitioner, originally the mother of your petitioner, namely Susila Devi, was the owner of such and such.
Yes.
What is the document of title of Susila Devi?
This is the title deed under page 70.
Document
sale.
of the title of this is the.
Page 30.
I'm sorry, give me a second.
Page 30, my lord.
When it was executed?
It was executed 9th day of April 2012.
So page number 30 is the deed of title.
9th day of April 2012.
Give me a second, sir. Dated 9/4/2012.
12. Another is, my lord, by 2 deeds, my lord.
Yes.
Center plot of land.
And what is the
Second, my lord. Page 52, my lord.
it is with regard to 5 kata, 7 chitaks, 12 square feet.
Yes. Second one is, my lord.
Second এটা হচ্ছে page number 49 এ শিডিউলটা। Where is your second deed, sir?
52, page number 52.
It is also in the name of Susila Devi.
Sushila Devi.
Page number 52. Deed of title.
And your lordship will find,
Give me a second, sir.
my lord.
Dated 22/10/2014. Very good. Where is the schedule of the property? Page number?
Page number, my lord, 67.
67.
Yes.
Page number 67 is the 12 chitaks, 6 square feet
Yes.
in 2246. Page number 67 is the schedule.
Yes.
Now tell me,
Thereafter, my lord.
your mother was a After purchase, the land was acquired, or before purchase, the land was allegedly acquired.
Notification in the year 1961, section 4.
So that
Yes,
notification.
I'm coming. Before that, my lord, can you turn to page 70? Is the my lord record of rights.
70.
Record of rights. Illa record of rights.
It is in respect of which plot number, sir?
Same, my lord.
Where from will get that plot number?
So-
2278.
Yes. Now it is standing in the name of the railway.
Page number 70, LRROR.
'72 is the first notification. Section 4 notification.
Very good. Then what happened, sir?
Section, your lordship is asking for that notification under section 4. That is at page, my lord, 72, August 22nd, 1961.
Page number 72 is the notification.
Yes.
Notification under section
4.
So 72 to
The similar, my lord, notification your lordship will find in the
just wait, sir. 72 to 76 are the section 4 notification.
section 4 notification.
Just wait, sir. 72 to 76
Section
section 4 notification
thereafter section 6.
includes which includes RS plot number
2246.
2246.
Yes.
Give me a second. Now show me the section 6 notification.
77, my lord. And except before.
Page number 77 to
79.
79.
79.
Section 6 notification.
Section 6 notification.
Here your land is not there.
Not yet.
In the schedule, your land RS plot number 2246 was not there. Very good. Then what happened?
Thereafter, my lord, this is next page is the, my lord, sanction plan.
No, what do I do with the
I'm coming, my lord. Thereafter, my lord, kindly turns to page 82 straight away.
81 or 82?
81 and 82.
81.
81 and 82. 81 is my lord, petition under section 6 of the right to information.
Very good. Then 82, sir.
82 is a reply.
Yes.
Kindly, my lord, takes page number 81.
Huh. Kindly place.
My query was that, my lord, please inform me the aforesaid property has been acquired or not. Kindly inform me that your competent, your department taken over possession on aforesaid land or not. If it is already acquired, kindly inform me that there been any assessment of compensation or not. If it is acquired, kindly inform me how much the amount of compensation can be. Now, my lord, takes the reply. 82. With reference to above, this is to inform him that the above mentioned plot has been notified in the Calcutta Gazette on 22nd August 1961. That is section 4 notification. Wide notification no Howrah 13690 LA 22nd August 1961. Wide No, number Howrah 13690, LA 22nd August 1961 in Calcutta Gazette under LA Act 11894. That is the only notification. Starts from page 70.
Then what happened?
Thereafter, Mara Railway Authority issued notice for stop work
That is at page number 83.
83 and 84.
Page number 84 is the stop work notice. Yes.
Now, my lord, turns to page 86, my representation, which this honorable court has, my lord, directed the, my lord, authority to consider. From second paragraph, my lord, kindly says, it reveals from the record, kindly, my lord, takes it. It reveals from the record that no declaration has been made as your lordship got it, my lord. It has been made as per section 6 of the Land Acquisition Act 1894. My mother, during her lifetime after her demise, was in the possession of the said property. Now we are in possession of the said property and constructed building thereon as per the sanctioned building plan. Suddenly, your good office has issued a letter dated 17 August 2021. But unfortunately, on 14/8/2023, my mother has died, and during her lifetime, your good office has issued a letter dated 17/8/2000 to stop the work without any legal authority. Our learned advocate has duly replied the same on behalf of my mother. Presently, your good office is claiming the ownership of the said land illegally and disturbing our peaceful possession without any legal authority or justification.
Then what happened, sir?
Thereafter, I came back before this honorable court. This honorable directed to consider my presentation.
That is at page number 90.
90, yes.
Very good. Coordinate bench orders.
Yes. Now, my lord takes, my lord, the report filed by the state authority. Now they have made a U-turn. Very interesting one.
State. Yes. Which portion is relevant, sir?
Report of the state authority, my lord, kindly takes the first page.
I'm there only.
Yes. Annexure P1, R1, sorry, on page 3. From second paragraph.
Yes.
In para 28 of the instant writ, it is mentioned that the suit plot doesn't appear in declaration 17004 dated 22/10/1961. I think small it is a section notification, section 6 notification. But the RS plot number 2246 was acquired long ago by LA case number 2 of 1943-44 for straightening of Howrah and Morigram Road. My lord, kindly says, my lord, this is a project. That is, my lord, straightening the Howrah and Morigram Road. And the notification under section 4 published under, my lord, Morigram Dankuni project. Completely two different. Howrah Morigram Road from the Thana Makua to Morigram level crossing. It appears the order sheet LA case number 2 of 1943 for that in the instance of the superintending engineer central circle, the suit plot RS plot number 2246 had been requisitioned under the Rule 75A of the Defence of India rules by the Provincial Government of India through Defence of India Act 1939, which gave liberty to the governor to issue rules for requisition and acquisition of immovable property under section 29 of the Defence of India Act 1939. From the order sheet as well as the possession certificate, it appears that the possession was delivered to requiring authority on 24/3/1943. From the letter bearing memorandum 2779 M dated 3/4/1943 of the superintending engineer.
So if it has been acquired on a long back, why it will be reacquired?
I'm coming to that, I'm coming to that.
Huh.
Even my lord, Supreme Court says, in my lord, larger judgment, bench judgment, Supreme Court says that once it is acquired under the Defense of India Act, cannot be, my lord, taken into, my lord, no shelter can be taken under the Land Acquisition Act, whether it is under the, my lord, compensation or not. Because in that case, my lord, case filed for, my lord,
No, this is specific case that in respect of LA case number 2 of 1943-44, it was already been acquired.
that is their stand, my lord. I'll show, my lord,
Huh.
how much land that was.
So why the court will
Even that is
disbelieve that?
alleged. My lord,
Why the court will disbelieve that?
but there is no corresponding document to that effect. Only they have filed this report. From the letter bearing memorandum number 277 AM dated 1/3/4/1943 of the superintending engineer, Defense Work Circle, it appears that though the land was initially temporarily requisitioned for the purpose of war, it was decided to acquire the land permanently under Rule 75A2 of the Defense of India rules. Accordingly, RS plot number 2246 of Mauja Dulia jail number PS Sakrail was acquired by the provincial government in pursuance of the Rule 75A2 of the Defense of India rules, and notification was published in the Gazette of India on 13/5/1943. 13/5/19, I will show mal that is my requisition notice. Notice were also issued in pursuance of Rule 75A2 of the Defense of India rules on 7/7/1943 to erstwhile owners of the suit plot, Vishnu Charan Patru, who is found to be the recorded Rayat, as found from the annexure P15 of the instant rate. From the another notices appears that Vishnu Charan Patru was asked to appear on.
Forget that. Tell me and just give me one answer. Why this court will believe these authentic documents?
Which one?
Why this court will disbelieve these documents?
Because there is no such document. Only they have.
No annexures have been given?
Yes, kindly take some. I'm coming. One after another, I'm coming to the annexure.
Huh.
Kindly takes their first.
Annexure A2, annexure A3,
Because,
annexure A4, annexure A5.
That is the legal issue, my lord. Kindly consider.
You are before a legal forum,
yes,
no?
yes. Defense of India Act. Only your lordship knows that it was a temporary statute. Before that, my lord, certain ordinance was passed, and subsequent acts also passed to regularize such, my lord, requisition. My lord, may I place that, my lord,
At the instance of Acho such and such has been requisitioned under section 75 Ato to Defense of India, which gave liberty to government issued rules for requisition acquisition under section 29.
This is
order sheet. On the order sheet has a position certificate, and the position was delivered to the requiring body. The letter after the when it appears the land was initially temporary requisition, it was decided to acquire permanent.
My lord,
Was acquired by the provincial government, copy of notification, annex A5. That is the document.
My lord,
A5 টা কোথায় রে বাবা?
Your lordship, my lord.
A5 is at page number 10. A5 is the
সেটা বলে দেবো না A5 and A6.
A6 my kindly tells the quantity of land, my lord, Vishnu Charan Patru 2246, but it is written, my lord.
সিউড়ি হাওড়া হাওড়া এটা কোথা থেকে পাবো দুইল্লা what is the plot number RS plot number
That is there, my lord, in 2246.
2246
Yes.
এটা আছে 2246 টা
2246, your lordship.
Page 11. কোথায় লেখা?
না কোথায় আছে নোটিফিকেশন? Page 10, my lord.
2246 is there.
For requisition.
2246 is there.
This is, my lord, under section 75A. Kindly consider. That is only says about, my lord, requisition, not acquisition. notification my lord starts. May 1943, whereas the property described in the schedule attached to this order has been requisitioned under Rule 75A.
Requisition followed by acquisition.
There is no acquisition.
Requisition is 10, acquisition at page number 11.
11 is
Absolutely.
not.
Bow down.
এ কিছু নেই মামলা।
Malad, how much quantity? Even if that document is taken into record. Malad, kindly see 22460.02. Page Malad A6, 10, 11. Even after filing of this report, I have also applied under the Right to Information Act. In that reply, they have also said only 0.2 acres. Now he is claiming the entire land. Will your lordship allow me to file this supplementary affidavit? Because after filing of this,
Mr. Dhar, why 2 decimal of land was acquired?
Kindly come to A5, page 9.
I'm there.
Whereas on the left hand side, 1, 2, 3, 4. Howrah on top, has got it. On the left hand side, Howrah, the 7th and 8th May 1943. Has got it.
Which one's the page number?
Page number 9A5.
Huh?
On the left hand side, first paragraph, then second paragraph, then third paragraph. Whereas the property described in the schedule, has got it. Howrah on top.
Yes, Howrah.
Howrah. Then, whereas the property described in the schedule attached to this order has been requisitioned under Rule 75A of the Defense of India rules. First is requisition. Then, now therefore, by virtue of the powers vested in me by Rule 75A2, I'll show that 75A2 deals with the acquisition, not requisition.
But
I declare.
Wait, sir, wait.
I declare that the property described in the schedule attached to this order is acquired, kindly mark it, by the provincial government in pursuance of Rule 75A2 of the Defense of India rules.
Yes.
So 75A requisition was followed by 75A2, that was acquisition. Now, my lord, kindly turn to the next page. Page 10.
2246 is there.
Yes.
Right hand column.
No, my lord, notification starts. That is a different notification. Howrah 7th and 1943 order.
The same notification,
Now
my
he
lord.
is referring the same. This is very unfortunate.
Huh? Xerox, while doing Xerox, it got
No,
top
fresh one. I have also fresh one also.
kindly see the top one. Same thing. Howrah 7th/8th May 1943 order. On top, will find the Midnapur 6th May 1943. On kindly go tally both the pages. On top, kindly find Calcutta Gazette 1st April to 26th June 1943. Kindly come to the next page. at page 10. Calcutta Gazette, 1st April, 26 June 1943. Only the Xerox was not properly done, so that's why.
Continuation.
Date is there, page is there,
Kindly see,
everything is there.
kindly see their reply.
বুঝে গেছেন?
Malik, kindly see their reply, Malik. To the
I've heard,
right.
I've heard.
Now, they are saying, Malik, 2 decimal of land.
It is pertinent to me, it is pertinent
43, that my your lordship has not mentioned, my lord.
Sir, your judge has
My lord,
exercised his best wisdom.
my lord, I appreciate, my lord.
So your appreciation will not
My lord,
do
I
anything.
only, my
I
lord,
have exercised my
my lord, I am,
my best of my.
my lord,
Let me come back after 2 minutes.
PRA, my lord, I mean,
My lord, may I be submitted to?
in the read in the nature of mandamus commending the respondent's authority.
Yes, sir.
PRA, my lord, I'm reading the nature of mandamus commending the respondent's authority for grant of compensation in respect of the said land of the petitioners acquired by the state government for reconstruction of Isla affected Sundarban or Sundarban
Embankment.
embankment. This is the land was acquired by the state authority for the said purpose, my lord. Then it is the petitioner is the all recorded owners, my lord. And lordship, I'm showing this, my lord. The land, my lord, kindly come to page 20.
Page 20.
Page 20, list of the plots, my lord. List of the plots were acquired by the state government for this said purpose. Page 20, page annexure P1. Those plots are, my lord, the top, my lord, the name of the owners, my lord. The first name, my lord, Shambhucharan Mollik. Second, my lord, Rinku Mollik, Devabroto Mollik, Tapan Kumar Mollik, and Manjurani Mollik. They are owners of the.
Who has prepared this chart?
My lord, several time.
My lord, I mean,
Wait, madam. You will get your chance. Take your seat for the time.
তুমি এখন বসো না। Lordship, it is a list of the plots, my lord.
No, page number 20 is a handwritten document prepared by whom?
Prepared by my client.
Prepared by your client. Very good.
Then the page number 21 to, my lord, all the records are, my lord, 21 to 53, 42.
How many read petitions are there? 4 read petitions.
One more than one. Lordship.
More than one. How much court fees you have paid?
Yes, my lord.
Are
This
they
is the point.
They are co-owners?
Are there owners?
They are co-owners or they are individual owners?
Individual record prepared individual.
How there will be a joinder of cause of action?
Cause of action means the plots are.
How there will be a joinder of cause of action?
Cause of action means that all the plots are acquired by the state government.
No. Those plots which have been acquired.
Yes.
The read petitioners are the joint owners of the same.
Accordingly, it is joint owners.
Where is your pleading to that effect?
My lord, and coming, my lord, and then, my lord, order passed by the state authority.
No, before coming. Double 273. Shambhucharan.
My lord.
Good.
All the records, my lord, it is separate records, my lord, prepared by the authority, my lord. Separate records. Page number, my lord, 21 to 53. All the separate records, my lord. No, it is not the point of, my lord. It is the point of the dispute. Point of dispute is another point, my lord. I am coming, my lord. It is all the recorded owners, lordship.
2724. Be there as it may.
My lord.
Yes.
My lord, come to page 44 and 43, annexure P3 and P4. It is a paper notification.
Page number 43 and 44.
44 and 45.
Oh, I'm sorry. Page number 44 and 45.
45. It is a paper notification for acquiring the land for this purpose.
44, 45.
44 and 45.
Under which act?
The act, my lord, they say the land reforms, acquisition, land acquisition act.
Under Act 1 of 1894.
My lord.
Chardharar Vidhan.
Yes, it is
The
dated,
44. 6 was done. 6-1 is also done. So acquisition complete.
Application complete, my lord.
Huh.
My lord. Then
Land stood vested.
vested under this state, my lord, for this purpose, my lord. Lordship, kindly come to page.
Act
Page-
1, my lord, vesting will take place, my lord, on delivery of possession, section 16. And
that's it,
Act
yeah.
2, my lord, upon 4-1 a notice being
No, 6 has been published.
6. 6
No,
is declaration.
Vesting complete.
No, in Act 1, my lord, vesting will not be complete.
It's not complete.
No. Act 2, my
Land,
lord,
land,
Act 2 it is complete. Act 1,
Let
upon
me-
award and delivery of possession, section 16.
Act 1 of 1994 টা কোথায় গো?
Act 1 আছে।
Land acquisition একটা বার করো না। কাল কিন্তু আসবে। 1894 একটা বার করো। Land acquisition 1894.
আমারটা
এই যে দুটো তিনটে বই রাখতে হবে না কি করে চলবে?
আমারটা সেটা বলে 1984 করে দেয়নি।
Have you brought, sir?
Act 1
কি আছে তোমাদের?
যে কারণে রিজেক্ট করেছে সেই একই ম্যাটার করে একটা ওই দুটো আপনি আলাদা পিটিশনারই নয় সেই কারণে রিজেক্ট করেছে না না এই ডেটটা যে নোটিফিকেশন অ্যাক্টিভেট হচ্ছে এই
section 16 possibly under Act 1 will not use vesting.
এনার নামে নোটিফিকেশনটাই অ্যালার্ট হয়েছে সেও পিটিশনারই নয় ওকে হ্যাঁ দিস ইজ দি অ্যাকচুয়াল ম্যাকেজ এই যে এই কারণে একটা আগে রিট ফাইল করেছে সেটা সুখা ঘোষ অর্ডার দিয়েছিল রেসপন্ডেন্ট
9394 অন্য লোকের নাম।
অন্য লোকের নাম যে জন্য রেসপন্ডেন্ট টু রিজেক্ট করছে সেটা চ্যালেঞ্জ করে এসছে কিন্তু আমাদের নোটিফিকেশন যেটা হয়েছে এটা এই নাম্বার না ওর নাম তো হয়নি রিজেকশন হয়তো তোমার এই নাম
অন্য লোকের নাম।
নামের লাইনটা নয় এটা আমাদের সেম পেজ আছে
পর্চাগুলো খোলা হবে।
না বলছি আগে
1994 নোটিসের নাম আমাদেরকে দিয়েছে আমরা আবার করছি।
যে ল্যান্ড গুলো বলছো সেগুলো এই লোকের নামে পিটিশনটা এসেছে ওনার নামে মানে নোটিফিকেশন এসেছে এনার নামে হ্যাঁ
Oh, section 6 subsection 3 says after publication of declaration the state government may the appropriate government may acquire the land in manner here appear.
Kindly take section 16 minute, possibly 16 gives the vesting under Act 1. So far as I remember.
Yes, sir. When the collector has made an award under section 8 will take poison, which shall thereupon vest absolutely yes. Section 16. Thank you, Mr. Banerjee.
Lordship.
Yes, then what happened, sir?
My lord, a notice was issued to another person, my lord, page 46.
36.
Page 46,
46.
Lordship. Another person, my lord, for payment of compensation. It is not my notice, my lord, another person. Petitioner came to know from that person. Here,
So let them have
My lord.
made a representation.
Lordship. Then my petitioner made a representation for page 47.
Mr. Banerjee, let special land acquisition consider the representation.
Order has been passed.
My lord,
Order is
I'm going
impugned
to-
here.
Oh, I'm sorry.
I'm going to. My lord,
Your representation is at page number 47 and 8.
for 47. Page number 47.
47 to 48.
Yes,
Your representation
representation,
for grant of compensation. Then what happened?
Another order was passed, my lord, by the Honorable High Court, my lord, in the similar case, my lord. The similar case, my lord, kindly.
No. After submission of
Not our-
representation, what happened?
My case is this, my lord, that after, my lord, filing this representation, my lord, I came to the Honorable Court, my lord, file a writ petition. Page 63.
Page 62.
63.
60?
63.
3. Adjust the microphone. Madam, please adjust.
63, my lord. The order passed by Honorable Justice Subra Ghosh. The ordering portion, my lord, kindly see page 63 to 60.
Such compensation is to be disbursed in their within a month thereafter. Very
Yes.
good. Then what happened?
Then kindly come to the order passed by the authority, my lord, kindly come to the last portion of the order, my lord, saying that all the plots are has taken over for the said purpose, my lord, purpose. But the last order, under the above circumstances, since the claim of the petitioner regarding compensation against the issued plots have been submitted at the belated stage after a long period of 8 years from the date of the publication of the award, as the instant writ petition did not file any petition within the stipulated period of the time. Thus, it is beyond the jurisdiction of the collector, South Chobbish Pargana, to adjudicate the claim of the writ petitioner as per statute. And paragraph 1, 2, 3, 4, all the plots have been taken over. It is stated in the order sheet. But only saying the belated stage.
It is said that notice under section 9 was not issued to you.
No. Then after knowing the alleged,
So you were not the recorded owners then.
I am the recorded owner. It is stated, my lord.
Where?
Paragraph 3, my lord, 6, the order sheet, page 67.
Place.
Page 67.
Huh.
The learned advocate, such and such, the verification of this, and next paragraph. Further, it appears from the office record that the aforesaid plots, along with other plots at Mauja Chemaguri, jail number such and such, were acquired by virtue of proceeding hearing LA case number such and such. The provision of
With regard to the
our land
4 and 6 notification.
our land were acquired.
Then during hearing?
Only he is saying that it is a belated stage.
No, just read, sir. During hearing.
During hearing, in the petition, petitioners categorically mentioned that the notice under section 3 and 4 of section 9 with section 11 of the Act of 1894 was issued to the occupiers of the said land, and such and such October 2013. The date has been fixed for hearing in connection with the compensation in regards to the said proceeding notice P5 in the writ petitioner. P5 is another notice to the another person, not our names there, and not our plot also. Only understand this is saying that in the circumstances belated stage. Land was acquired. And the embankment already finished. And other persons are getting compensation.
So what document were there that at that material time you were
No,
the recorded owner?
It will not say they stated
The
here.
Banerjee,
What I find from the writ petition, my lord, are some record of right which are of 2015. The ground is that they have failed to produce a document to show that they were the recorded owner at the
Ah.
given point of time. And what they have annexed in the writ petition, they have annexed here also, that is in respect of some other person.
No, they are saying that they're our plots and they are saying only the belated
during
stage.
hearing and in the writ petition, petitioners categorically mention the notice under section 9, read with section 11,
Page 46 of the writ
was
petition.
issued to the occupiers of the suit land there, and on 31st October, the date has been fixed for hearing in connection with the
Lordship will kindly see paragraph
Not our case.
paragraph 6 of the writ petition. The
Paragraph?
averment 6 of the writ petition, that is the averment. Paragraph 6, that the state government issued notice to persons who were the recorded owners in their lands under subsection 3 and
Another
4.
person, not our case.
Yes. And on 31st October,
Persons-
the date has been fixed for hearing in connection with the compensation. It is annexed as annexure P5, which is at page 46.
It is not our.
Annexure is in name of
Our
Wait,
Mukkini Pottunar.
Huh?
This is in the name of Mukkini Pottunar. To her, my lord, award was declared.
Just a minute, sir.
The petitioners,
Para 6.
para 6,
Then page number
46. This is the only document that he relied upon regarding the acquisition. And some record of right which are of 2015, subsequent record of right have been relied on. If your lordship sees the record of right annexed by them,
I annexed, my lord. Another person got the same note, got the
No. At that material time, your name was recorded.
yes.
I will get that.
The record are here. All the records are here.
These records
They are
of
not
right of
now.
which day?
Lordship kindly see. My
Can you see the
underpin
date?
is wrong.
page 21,
এখানে Lordship kindly see the order portion.
come page
Order
21.
portion, they are not disputing our land. Page 50, page 67.
Declaration under section 6 was passed on
There's a my lord kindly.
This was passed on prior to 13.
2013.
13.
So produce any document with prior to 2013.
They have not, they failed to produce. That is the problem.
No, Lordship, one thing. Another person received the notice, this notice. The authority did not any issue notice to the petitioners, my lord. But land was acquired.
Take down.
And the plots are my lord,
Same, my lord.
Same order.
Auctioneer Patnaik,
Date of the order is same.
same.
Already same.
তো একই order করে দেবে।
My lord, one thing I pray,
দিয়েছি এই আর একবার দেবো নাকি
the direction to the authority, I shall,
ওটা আমার
Sorry?
I shall, with the direction to the petitioner to make a shop all these papers to the authority, and authority will consider.
No, no. You file a separate representation.
tomorrow for extension of interim order because interim order will expire on Monday. But I don't know. I tried to.
Who have not mentioned and the proceeding of the court.
No, my junior has mentioned he actually allowed the matter and directed the matter to appear on Monday. But that is my lord. Now, my lord, I
It has not been listed. It was supposed to be listed on which day?
supposed to be listed on. Your lordship told if the file comes today, if not come, then Monday.
Monday, wait for Monday.
Monday is the last day. That's why I'm just
Reminding.
because my lord, today was if the file comes today, if not, then Monday. That's why today is not appeared. Then my lord, I'm just apprehending.
They can file টানিয়ে নাও ব্যবস্থা করো Monday চলে আসি জানো বিকাশ মানডেতে ফাইলটা নিয়ে আসার ব্যবস্থা করো in the event it is not listed on Monday please mention yes
My lord, petitioner.
what is this affidavit of service is there any private respondents sir?
Yes, my lord. Three private respondents.
Have they been served?
Yes, my lord. I served on Thursday.
Service has been affected?
Lord, update status is not available due to server problem.
Then?
But all the concerned authorities are served.
No, they are to be served, no?
My lord, my prayer for my lord.
Whatever may be your prayer.
Magistrate for my lord.
Where is your কি বলে সব
Just only necessary party.
where is the postal tag report with regard to the private respondents?
My lord, it is not available, my lord.
No, then it
Due
will
to
be
server
taken up.
problem, my lord. But the other concerned authorities are served, my lord.
Whatever we have to serve them also.
No, it is served, my lord, but it is track is not available only. I served on Thursday, my lord. Same day when the leave is granted.
When the notice was filed? When the notice was sent?
Thursday, my lord, last Thursday.
4th September.
Yes, my lord.
Where is the track report?
The track is not available due to server problem, my lord.
Then make some arrangement, alternative arrangement.
Yes.
Where do they reside? How can it be?
No. But I have served all the concerned authority they have received, my lord. My prayer is for the non-action of district magistrate Howrah, my lord. Due to the soil erosion, I am at alarming position. My dwelling house are going to.
The affidavit of service has filed today.
I appear, my lord, for the respondent number 4, the private response.
And for the petitioner in this
Who's for
matter,
the state?
the state is a very important party.
I have a point of maintainability here. Once my learned friend plays his case, I'll.
But who is for the state?
Mr. Shomrat Sen is appearing for the state.
Where is Mr. Sen?
I have informed on last day, but
Private dispute. If anything before arbitrator.
no, not
Now,
That has his name. State is to be represented, no?
his representation is required because this is in respect to our land, wherein a lease has been granted by the urban development.
The writ petitioner and the private respondents are represented by their respective councils. কি বিপদে যে পড়া গেছে না। রেসপন্স নাম্বার 2 এর নাম হচ্ছে ওয়েস্ট বেঙ্গল ইলেকট্রনিক্স ইন্ডাস্ট্রি ডেভেলপমেন্ট কর্পোরেশন। 3 নম্বরের নাম হচ্ছে দ্য ম্যানেজিং ডিরেক্টর ওয়েস্ট বেঙ্গল ইলেকট্রনিক্স ইন্ডাস্ট্রি ডেভেলপমেন্ট কর্পোরেশন লিমিটেড।
Same.
এখানে লেখা আছে টু দি স্টেট অফ ওয়েস্ট বেঙ্গল। কি করে দুটো এক হয় আমি তো মাথায় ঢোকে না।
Later, Lordship will kindly see the letter, madam. First, Lordship will kindly see the letter. Lordship will kindly see, madam. Page 3. I have given every niche and every name. Everything has been given on the letter, madam. We have served the copy, madam. That is
The
only.
letter was addressed to me
Yes, madam.
and it was sent to my SEO.
Yes,
Does
yes.
it mean that it has been served upon me?
It has been served. The learned lawyer also have present.
Where is the service?
This is the service, madam. I have sold. Lordship will kindly seize the madam track record. Lordship will kindly seize, madam. Item delivered. Item delivered on address. Well, if your lordship is not satisfied with the service, my lordship, I have already mailed him, man.
Show me the postal receipt with regard in the names of the respondent number 2 and 3.
The postal receipt, it's a short thing has been given, but my letter says everything. Lordship will kindly see the letter.
The postal receipt indicates
this is
the state of West
given.
Bengal, not West Bengal India.
I have already, my lord,
I
given.
can see only Sen who is sitting in front of you. I do not find any Sen being standing in front
I
of you.
should
What
not
can
say
be done,
something,
sir?
my lord, which is beyond the record, my lord. Mr. Shane has, my lord, I personally, my
Sir, I
lord,
believe you. You serve a notice. In case he does not appear again, you will suffer.
my
Which
lord,
is why I passed an order. Kindly, what is the difficulty in complying the order?
my lord,
You are making unnecessary bargain with the court. That too with a small thing and there's a service.
my lord, let us retain his positioning within, my lord.
So that I have indicated. Should I again return it? Not to the notice to be served at the writers building, not to the city civil court building. একটা লাইন অ্যাড করে নিন তো ফাইলের নিচে নামিয়ে ডিপার্টমেন্টে নামাবেন Mr. Mukherjee, your matter is supposed to appear on tomorrow. It will appear tomorrow. Who is for the writ petition?
My lord, I appear for the petitioner, my
Mr.
lord.
Galib is for the state.
The rectification of record of rights, specified act.
Sir, give me a second. Is there any private response, sir?
No.
Carry out the rectification of the LR record.
Well, the rectification order was given long back. As early as in the year 1994, there is a recording. I have annexed that document to this writ petition also, that they have complied with it. The only thing is, it is
Who will record?
Well, the BL and LLO.
So go to the tribunal.
Well, I'll just indicate one thing. Thereafter, obviously, my lord, I'm in your lordship's hand. It's a specified state act. I'm not standing in the way, but there's only one thing. There's one particular compliance which needs to be done and nothing else.
Sometimes you people take advantage of the ignorance of a judge.
No, absolutely not. This is something, my lord, I've indicated to my learned juniors also. But the difficulty, my lord, is again, your lordship knows, going before the tribunal, the matter would be, it can be disposed of in one single day.
What can be done, sir? We are living in such a society.
Lordship.
It is not maintainable. Take down.
If your lordship just looks at the order, thereafter I wouldn't make any further submissions.
Take your seat. Show me.
My lord, I'll just indicate the brief facts first. The property belonged to one Uttam Dai Mehra. There was this particular vesting proceeding which was initiated. Thereafter, prior to the vesting proceeding having been initiated, Uttam Dai Mehra had sold the property in favor of one Kamaluddin. Thereafter, there was it by way of a registered instrument. Thereafter, by way of a registered deed of exchange, the property was exchanged between the predecessor and interest of the writ petitioners and Kamaluddin. Now, my lord, at that juncture, the state said that no, the vesting procedure had initiated and the property now vests in the state. What the predecessor in interest of the writ petitioners do is they file a suit. In the trial court, they suffer. No decree passed. In the appellate court also, the appellate court confirmed the decree passed by the learned trial court. Now, thereafter, my lord, a second appeal was carried before this honorable court, where the trial court's decree as well as the appellate court's decree were reversed, saying that the state is perpetually injuncted from interfering with the possession. And thereafter, my lord, in the year 1994, there was this proceeding initiated. Obviously, my lord, at that given point of time, the West Bengal Land Reforms and Tenancy Tribunal Act wasn't there. So, my lord, at that given point of time, there was a direction given that the name of the writ petitioners be recorded. Now, my lord, I wouldn't trouble your lordship. I'll just directly take your lordship to the most pertinent document, which your lordship will find at page 56 would be the first document, my lord. 3 documents I'll cite, my lord. Page 56, annexure P9. In connection with the above cited subject and reference, he is requested to communicate with the office of the undersigned for undersigned for his application for correcting the RS record as per the order of the Honorable High Court at Calcutta, Vide WP number such and such of 1994. This is the writ petition, my lord, which I was talking about. So, my lord, there was already a direction for correcting the record of rights. Now, my lord, thereafter, we approach the ADL and DLRO at page 57, my lord. I'll just place this document, my lord. In connection with your letter regarding application for seeking information under RTI Act of Mamtazul Karim Faruqi, we read number such and such, Purva Bardhaman, dated 14th February 2019. We've gone through all the office record thoroughly for consecutive several days and left no stone unturned to search out whether any proceeding was initiated for RS record correction under section 44(2)(a) of the West Bengal Estates Acquisition Act, or any record of RS stage is corrected or framed as per order of the Honorable High Court at Calcutta, Vide writ petition number such and such. So it's recorded, my lord, that there was a direction for rectification 44(2)(a), that there was a specific direction to that effect. We came to learn that deed and BL and LRO. I beg your pardon, Lordship.
BLRO Guskora disposed of the matter.
Yes.
Then what happened?
Then, my lord, the very next page is the direction which is recorded. My lord will find that this letter is being issued by the page 58 is being issued by BL and LRO to the District Land and Land Reforms Officer. I'll just place this record. Reference to the above memo. This is to report that as per the order of the Honorable High Court, Calcutta being number such and such, the proceeding is initiated under section 44(2)(a) of the West Bengal Estate Acquisition Act of such and such Moja, has been disposed of on 9th January 1996 by this end, that the RS record of right has been corrected in favor of the petitioners. So that is why, my lord, I say that at this juncture, all that I'm seeking for, that they correct it. There is a formal direction. I'm not challenging the procedure. I'm doing nothing insofar as the order is concerned. There is an existing order which has already been carried out. It needs to be effected in the records. That is all.
So your RS record has been corrected.
But it is not getting reflected in the records.
Then it comes under the inaction. Hey, West Bengal Land Reforms Act Parko.
Perhaps, my lord, I'll also indicate that your lordship will perhaps get it in the WP LRTT Act section.
Take down. Oh, when I'm sitting with Justice Chakraborty. Grateful, my lord.
না
কত নোট করেছি এখন কি হয়
এত হেভি হেভি বডিলি মাস দ্য রিয়েল হেভি দিস সাইড তুমি তো ওই দিকে আমাদের দিকে চলে এসো তাহলে হেভি হয়ে যাবে আমরা
গ্ল্যামারটা দেখেছো?
হ্যাঁ দেখতে পাচ্ছি
না পাশে
গ্ল্যামারটাকে দেখো
পাশেরটাকে
কালকে
দেখেছো?
কালকে তুই করলি না কেন
তো হেভি ওয়েট কিন্তু মুশকিল আমি কিছুই নেই হাওয়া
ওই যা আছে মাথাটা তো আছে ওটাই তো যথেষ্ট
আরে ওর কি মুশকিল
Mr. Basu,
yes
when pleadings are complete, it should not have been in the motion.
Oh, your lordship has posted this as a fixed motion.
Might was
Should
kind
not have
enough when the matter was taken up might was
Not
kind
have
enough kind enough to fix this that and nowadays those days has gone before
But they
vacation
are
hearing
enjoying
can be
an
taken up
interim order till the end of November, I believe, subject to correction.
Mr. Mojumdar is appearing on behalf of
WBIIDC. The main
industrial
Infrastructure Development Corporation.
ক্লায়েন্টের নাম জানিস না ফি পাবি না
তুমি জানো পুরো নামটা বলো তো
আমি তো ফি পাবো না
who is for the state.
চরণ দে চরণ
One.
But the main answer
So
is
you are 2, 3,
4, 5, 6.
and 4, 5, 6.
6. Very good. But this will continue. This will take time.
এসব বলে হাওয়া দিয়ে লাভ নেই কোনো জজ সাহেব এসব যেখানে ছিল সব বোঝে তোমাদের কাজকর্ম আর দাঁড়া না
Interim order তো এনজয় করছি বড় বড় কথা বলছিস কেন?
Yes, Mr. Basu, please the case.
point is very simple my lord a lease was granted in favor of a company with the clause of resumption
Short intervention, I think the big councils, it may take some time.
No big council.
heavy on
Kindly
council.
excuse me. My matter is item 15. So let them continue.
না না বেশিক্ষণ লাগবে
বলা যায়
বেশিক্ষণ লাগবে
আমরা তো বলছি আমরা কিছু বলবোই না
তাহলে হিয়ার মি বলো দেন
Mr. Bhattacharya, all are big except me. So be rest assured.
biggest
You're right.
Yes, Mr. Basu.
a lease was granted in favor of a party with the cause of resumption if you don't do these things for the purpose it was granted to you it will be resumed as usual clauses are there with a specific time
Lease is for
land has been given for the purpose of industrial purpose industrial park it appears my lord from the records I can say it is an admitted fact the purpose for which it was leased out has been my lord fulfilled the resumption clause says if you are unable to do it the purpose for which it was granted it will resume
so there cannot be any cause of action for resumption
What is
according to you.
what happened my lord thereafter with the concurrence of Mr. Mojumdar's client the lessee assign it to me
So you are not the lessee.
assign it to me with the concurrence of the original lessor for specific purpose in that deed by which I was assigned there was no clause for resumption
Very good. In the second deed, you are the original lessee was a confirming party.
yes with their confirming তাই তো বলছে উফ it was given to me for educational purpose institution this but I repeat my lord there is no clause for resumption now my lord according to us we have done something not everything now the original lessor want to resume whether that is permissible
That is permissible or not?
whether that is permissible or not my lord has to decide that coupled with the fact that we have may not be fully completed but certain thing has been done thereafter deliberations were made they ask us to do certain things, they given it to me, I give a plan for how I will execute this job.
So Mr. Basu, on execution of the second deed, rather deed of assignment, the original lease come to the leasehold interest has come to an end.
Assigned to me, but in the deed there was no clause of resumption. Resumption can be made by the
no.
I cannot say it come to an end because residual part has been given to me.
Oh, I see.
I cannot say.
So leasehold interest has not been extinguished.
Leasehold interest which was given to my
original lessee.
In law I can argue it subsequently that the purpose has been fulfilled for which resumption clause is there. Am I clear to my? There is a resumption clause vis-a-vis the original lessor and the lessee. That has been fulfilled, expressly written. Thereafter, it was assigned to me. And that assignment did, there is no resumption clause because there cannot be any. The original purpose has been fulfilled. Now, thereafter, I stepped into the shoes. I started doing the activities of education institution. I have started. The original purpose for which I was given the education institution, I started doing. Initially, they were not happy with my progress. They give us a notice, ask me to give a action taken plan, how it will be done that. I have given that. Initial plan was rejected by them. Subsequently, again the plan was given. When the ultimate impute order has been passed, the subsequent plan, the planning which has been asked me to given, has not at all been considered while rejecting the claim. These are the sum and substance of the matter. Now, my lord, another point is the second sequence notice. No notice, no hearing was given, and not only that, my second plan, which was given at the their instance, had not at all been considered.
And ultimately, what order has been passed?
Termination, followed by resumption. Power nai go. Kindly come to the original lease at page 37.
Extinguishment plan, right?
Page 37, kindly come.
You are enjoying an order of status quo.
Yes.
Let me hear it after vacation, sir, not now. It's very difficult to hear all matters. You are enjoying status quo, no?
The first week after, first or second week after reopening. Kindly keep it as a fixed motion, my lord, so that that can be accepted.
No, it will be listed as an adjourned motion.
But my lord, only some time may be fixed because my lord, the interim order is valid till I think.
Mr. Basu is enjoying the status quo order.
Up till now, which my lord, it is not in my mind. Limited period was.
But it is still
the last day of November 2025.
End of November, subject to correction.
So very good. It will take some time.
Yes, ma'am.
The point is this.
Very good, sir. And I can recollect. Asur.
My effort gone.
No.
For my purpose, it is
Mr. Basu is always successful.
Can it be hardened part with consent?
I have no problem.
Not required.
Well, I have no problem.
Not required. Yes, call the next.
If the bench is changed, my lord, again I have to ram to get done.
But so far as I am concerned,
maybe it will be better for you.
No, my lord, I have no objection. My lord, I have no objection.
For the first time, he is consenting something.
No, my lord. These prayers I never oppose. This is not my practice.
Grateful. Those days has gone. My lord is thinking of my lord's initial days here. Then I will not be here for I will be attending this matter. The matter is now filing is 50%. 50%.
All appeals advocate.
वो सब दिन भूलेगा जी. If I say our day's story to a junior who has come today, immediately that lady or boy will say बुड़ो बुल मारছে. ये सब কিছু হতো না.
My lord. Lord, this relates to
Lord, as for the status content raised by Mr. Supratim.
And who is for the corporation?
Lord, very short
Who is for
issue.
the corporation? You are for the corporation. Who is for the state then?
My lord, I am for the state led by Mr. Supratim.
Yes.
Lord, very short issue.
Yes, sir.
Lord, I have served this my affidavit service. My lord, a mining lease, my lord, was granted for extracting sand. My lord, lease was executed. My lord, in the meantime, my lord, the pandemic intervened. The mining activities, my lord, were disrupted. My lord, due to my lord, the logistic, my lord, being affected, that I would not be able to transport, my lord, the extracted sand. And this was, my lord, in for 2 periods, one in 2020 and another in 2021. My lord, in various judgments of my lord has, my lord, taken note of those 2 periods. Then, my lord, in respect of my sand block and my lord, other sand blocks, my lord, of at least 2 blocks, one in Jamuria and one is in Baraboni, my lord, there was a matter before the Green Tribunal. My lord, an interim order was passed, my lord, all mining activities were stopped. Eventually, Lord, the authorities were directed to hear us and then pass a reasoned order. In the reasoned order, my lord, it was held that we should be permitted to resume mining activities again. So this was another period of disruption, and the total cumulative period of disruption of the pandemic and the one, my lord, which I was precluded in view of order passed by the district magistrate was, my lord, 2 years and 9 months.
You prayed for extension of the period.
And during the subsistence of my lease, Lord, which was to expire on 8th of November 2022, Lord, I prayed for an extension. Lord, my prayer for extension, Lord, was not being considered. I came up before this honorable court. This honorable court, Lord, directed that my prayer should be considered. My prayer was considered and it was rejected. But against that, I again came up before this honorable court. A plea was taken that an appeal under Rule 51 of the 2016 rules is permitted. A leave was granted. I preferred an appeal.
Before the commissioner?
Before the commissioner. The commissioner has now rejected my claim on 2 grounds. One, that I have suffered no loss because 60,000 cubic feet I have extracted. That is the first thing. Second thing is, my lord, the 2021 policy, my lord, has come into effect. And my lord, the third ground is that the COVID circulars, my lord, they are not applicable in my case. These are the 3 grounds. Now, insofar as, my lord, the first ground is concerned, my lord, I come to the pages later. So far as the first ground is concerned, the lease deed provides for that I should extract a minimum amount of 60,000 square feet, or else, my lord, there are penal consequences. So it's not that because I had excavated 60,000 cubic feet, so now I did not suffer any loss.
60,000 cubic feet per annum.
Per annum. Second thing is, my lord, that this is, my lord, the fundamental fallacy is that the lease is for a tenure, not for quantum. The lease is for a period of 5 years. It is not for a quantum. The quantum specific is only
to the effect that if I default in lifting minimum 60,000 cubic feet, then I will suffer penal consequences.
Because they will suffer the loss
Revenue
of royalty.
The state exchequer will lose. Lord, the second thing is that, my lord, our honorable court, my lord, has held, my lord, that this policy will not prevail over the rules. And there is nothing even in the policy, my lord, which debars an extension. I have prayed for an extension. Policy says of renewal. I'm so sorry. The policy says of renewal. I am on an extension of a period which is covered by pandemic, and the terms of the lease deed provide for disruptions because of force majeure. That period would be added. The words you use is the period would be added. The other part is, my lord, where the district magistrate asks me not to carry on the extraction in view of an order passed by the National Green Tribunal. And then he asks me to resume excavation. This entire tenure of 2 years and 9 months, my lord, I have asked for extension. Lord, may I very well briefly take, my lord, to the order passed by the commissioner, which is at page 194.
One
194.
But it ends at one page 134.
194.
Yes, sir.
My lord.
But your writ petition ends at page number 134.
Lord, there would be 2 volumes. my lord.
Oh, I'm sorry.
I'm so sorry.
You should have indicated otherwise.
Yes, yes, my apologies for that purpose.
No, it's all right. Yes.
Now, my lord, 90 sees this is, my lord, 15th of May 2025.
Yes, sir.
Lord, this appellate proceeding arises from an appeal preferred by so and so under Rule 51 of the West Bengal Minor Mineral Rules 2016 against the order dated 6th December 2022 issued by the ADMLR. So and so, the appellant has been granted a long-term mining lease by the state government over so and so for the purpose of sand extraction through deed number so and so. The lease deed was executed on 12th October 2017 and registered on 9th November 2017, valid for a term of 5 years, extending on, this would be expiring on 8th November 2022.
Yes.
The appellant began mining operation after taking possession of the land and complied with royalty payment and statutory obligations during the currency of the lease. The appellant's primary grievance is that due to the unforeseen outbreak of COVID-19 pandemic and the resultant national-wide lockdown from so-and-so period to so-and-so, followed by continuing operational and logistic disruptions, his ability to conduct mining activities was severely impaired. He submits that despite multiple representations, no compensatory relief was granted. The appellant invokes the force majeure clause, clause 5 of part 9 of the lease deed, and cites office memorandum number so-and-so dated 13th May 2020, issued by the Ministry of Finance, so-and-so, which acknowledges COVID-19 as a force majeure event. On this basis, he seeks either extension of his lease period to offset the lost time or allotment of an alternative sand block for equivalent compensation. Then the decision. This authority has carefully considered the grounds of appeal, the statutory framework governing mining leases, the lease deed provisions, and relevant administrative policies, including the West Bengal Sand Mining Policy 2021. It is first necessary to clarify the legal character of the force majeure clause contained in the lease. While the lease does contain a provision that recognizes delays caused by force majeure events and provides that such period may be added to the lease term, this clause must be interpreted within the larger statutory scheme and prevailing executive policy. Lord, this is, Lord, the first ground, my lord, where I join issue. Then the Mines and Mineral Development Act 57 is a central legislation governing the grant and regulation of mining leases across India, and state-specific rules such as West Bengal Minor Mineral Concession Rules 2016 are framed under its authority. These rules, as well as a term of lease deed, stipulate a fixed tenure of mining lease. Although the lease clause allows consideration of force majeure, such extension cannot be claimed as a matter of right beyond the outer limit of the lease's validity. Let I pause here for a moment. My lease was to expire on the 8th of November 2022, and the extension, my lord, was sought much before that. It is settled principle in administrative law that leasehold interest, once expired by efflux of time, do not automatically revive or continue merely on equitable or compensatory grounds unless a valid statutory mechanism for renewal or extension is provided and followed. This is not applicable. I shall show that my application is anterior to my date of expiry of lease. Then, the instant case the appellant's lease expired on 8th November 2022. By that time, the West Bengal Sand Mining Policy 2021 had come into effect. Clause 6 III of this policy clearly provides that upon expiry of the existing mining lease, such lease shall not be renewed and automatically revert to the state government. My case is not of renewal. It further states that the government shall thereafter lease such sand blocks to so-and-so or any agency nominated by it. This policy decision reflects a shift in the state's regulatory approach, emphasizing centralized management of sand resources and transparency in allocation through designated agencies. The policy, having been issued under lawful authority, is binding on all executive subordinate administrative bodies. Therefore, even if a disruption had occurred during the lease period, the expiry of lease on 8th November 2022 extinguished the lessor's right to claim any extension or continuation. Then the appellant's reliance on Ministry of Finance memorandum number so-and-so is noted. However, it must be clarified that the state office memorandum pertains to public procurement contracts and was issued under the general finance rules applicable to contract executed by central government departmental agencies. Mining leases granted under the statutory mining framework operate in an entirely different separate domain governed by sector-specific laws. There is no indication that the sales office memorandum was intended to be extended to mining leases, nor can it override or amend provisions of the 16 rules or the sand mining policy. The fact on record further indicates that the appellant continued mining operation during 2021. Official challans issued to the appellant shows that 60,000 square feet of sand was extracted during that year, which is a contractual obligation of the lease as per Part 7 of the lease. These figures suggest that mining activities were halted in the entire period, as he demanded that the operation output remained significant despite pandemic-related constraints. While the appellant may have encountered difficulty due to reduced labor availability and transportation bottlenecks, these circumstances were common across the sectors and cannot per se create a legal entitlement to lease extension. It is also relevant to note that the policy rules 2002, the appellant was permitted to stock, store, extract sand and thereby mitigate logistic delays. Appellant did not apply for renewal or reallotment during the currency of the lease. My case is not neither for reallotment nor for renewal, nor was any formal invocation of force majeure made before the lease expired. I shall show this. His belated representation made after the expiry of lease lacks statutory footing and cannot revive a leasehold interest that has lawfully terminated. So he talks about belated representation. And then the court granted liberty to the appellant to approach appellate authority under Rule 51 with a specific direction that the appeal be considered on merits and not be dismissed on limitation. Accordingly, the present appeal has been examined fully on merit. However, the comprehensive review of law applicable, the lease agreement policy directives, and the factual, this authority finds no justification interference with the order passed by the additional district magistrate, Paschim Bardhaman. For said reason, the appellate authority considered the justified. Now, my lord, kindly sees that the lease, my lord, was granted page 77. Will I give the relevant dates?
Yes.
The lease was granted, executed on 12th October 2017
Yes.
and registered on 9th November 2017. My lord would very kindly find that at page 77.
Yes.
For the present purpose, part 9 at page 20.
Internal page number 20.
120.
Yes.
Part 9 at page 120 is relevant. My lord would directly come to page 121.
Yes.
But this is relating to force majeure clause.
Which one, sir?
5. Failure on the part of lessee to fulfill any of the terms, conditions of the lease shall not give the state government any claim against the lessee or be deemed a breach of this lease insofar as such failure is considered by the state government to arise from force majeure. And if through force majeure the fulfillment of the lease or any of the terms and conditions of this lease be delayed, the period of such delay shall be added to the period fixed by this lease.
Yes.
Page 156.
Force majeure means act of God, war, insurrection, riot, civil council, strike, earthquake, tide, storm, tidal wave, flood, other happenings which the lessee could not reasonably prevent or control.
Now, the central government notification as well as orders passed by our court and the Honorable Supreme Court has treated the pandemic to be within the purview of force majeure in respect of the government contracts.
It is other happenings which is not under control of the lessee.
Yes. Yeah. So
then what happens thereafter, sir?
Now, this is one period covered by the pandemic in respect of which I say part 9 clause 5 is applicable and this period should be added. But kindly see now page 156. This is not an order, a memo issued by the district magistrate and collector Paschim Bardhaman dated 7th July 2021. Kindly sees the last paragraph. Therefore, in compliance of the above solemn direction of the Honorable Tribunal, you are directed to stop all types of mining activities with immediate effect till further orders by the tribunal. This is addressed to me. My lord, kindly see the addressee of this letter is the petitioner before my lord.
Very good. Stop work notice.
Yes.
Practically stop work notice.
Yes, ma'am. Now, my lord, kindly, my lord, see is page 169. And my lord would, before that, my lord, kindly take a note of the date of this at page 156. This is 7th July 2021.
Yes.
And now, my lord, kindly comes to page 164. Paragraph 13, this is in continue. I'm sorry.
Page number 164, sir.
My lord.
Yes.
Lord, kindly skip over 64, kindly come to 169 because 64, my lord, the net effect I have already placed before my lord. 169, I'm sorry. June 2022.
Yes.
Lord, this is a decision of the ADMLR. Lord, the relevant portion is at page 170. My lord, kindly sees the third paragraph starting with the words, hence considering the facts that.
Yes.
All the long-term mining lease holders under Jamhuri and Barabani are having valid mining lease. All the concerned LTML holders possess valid environmental clearance certificate, and in view of the mitigating scarcity of sand for different development projects and loss of government revenue, it is hereby ordered to resume mining activity.
It is on 10/6/2022.
My lord. So 7th July 2021, and this is 10th June 2022. This is the second period.
Almost 1 year.
Almost.
1 year, 3 days.
My lord. But this is the second period. Now,
And which one is the first period? The COVID period.
the COVID period. Now, my lord, my representation, my lord, would very kindly find at page 172. My lord would very kindly, my lord, see the subject, prayer for extension of time limit. Prayer for extension of time limit of sand mining lease period for 1 year from the date of expiry of so-and-so due to COVID-19 pandemic across the world. Lord, kindly sees the date of this letter. Lord, this is 23rd of February 2022.
Yes, sir.
Milord, with regard to this date, Milord, I have two submissions. One is, Milord, that this is the period when the stop work, Milord, direction of the district magistrate was still operating on me. Hence, I could only pray for extension insofar as the COVID period is concerned.
Your deed of lease was executed on 9/11/2017.
My lord.
So,
And was to
22. So it is expiring on 8/11/22.
My lord.
And you have filed this on 23/2/2022.
Yes.
So within the validity period of the period of lease.
The commissioner has said that it
stop
is
work notice was issued on 7/7/21, resumed on recalled on 10/6/22. So you submitted representation on 23/2. Yes.
and then page 173.
173
is my second representation dated 4th March 2022. But these representations were not considered. I came up before this honorable court as I submitted, my lord. Kindly comes to page 176. Lord, kindly note the date 21st September 2022. Lord, kindly come to page 177. The last paragraph of page 177. In view of the above, the writ petition is disposed of directing the third respondent to consider dispose of the representation submitted by the petitioner on 23rd February 2022 and 4th March 2022 within a period of 6 weeks from date.
Both the representations were directed to be considered.
My lord. Lord, I went before the authority concerned. I'm so sorry. I went before the authority concerned and I submitted my written notes of submissions, which is at page 179.
Yes.
Lord, kindly see the relevant part of this. What did I ask the authority to consider when he was considering my two representations? My specific prayer is page 184, the last paragraph. Therefore, the petitioner, Therefore, the petitioner humbly prays before your esteemed office to pass an appropriate order for excluding the lockdown period of 21st March 2020 to 31st May 2020, and again in the year 2021 on and from 16th May 21 to 30th June 2021, and the suspension period on and from 7th July 2022 to, this should be 21, 7th July 2021 to 10th June 2022.
So those sum total are 2 years, 9 months.
My learned junior milord says that it is only 2 years, not 2 years, 9 months.
No, total suspension of work is for 2 years.
Milord, yes. It's about 2 years, milord. About 2 years.
That much does
Exact calculation করতে বছর 9 মাস কেন হবে? এখানে কোথায় 1 বছর? Less than 2 years. আর পেয়েছো সেটা এক্সাক্ট বলতে হবে।
It is 14 months, 33 days.
My lord. And
14 months, 33 days.
yes, and my lord, I in the prayer before the authority, I have specified not the total time, but the period.
The period is total is 14 months, 33 days.
My lord, I stand corrected.
Yes.
Now, my lord, this
14 months, 33 days, it has, sorry, it stands to 15 months, 3 days.
My lord. My lord.
14 months, 33 days, you have 15 months, 3 days.
My lord. Now, my lord, page 186.
Huh?
Yes.
The order of the ADM.
My lord. This is 29th of November 2022. Lord, I need not place this because, my lord, this has been affirmed by the appellate authority.
Dealt with by the commissioner.
Yes, yes. Lord, the date is at page 187, 6th of December 2022. And in the last paragraph at page 188, that he says, considering the above fact, it is concluded
Page
undersigned.
number 191 is my order.
But I come to that.
Oh, I've directed to hear out the appeal.
My lord.
Very good.
But I challenge the order passed by the ADM by filing a writ petition. My lord
I understand.
granted me liberty under Rule 51. Second reply.
Anything more, Mr. Chaudhary?
Yes. Now, my lord, kindly, my lord, comes to page 98. Only page 90.
Page 98. 98.
My
Yes.
Now, my lord, page 98 is a part of the lease deed in part 7. The previous page, page 97, shows part 7. And page 98, what I am showing clause 3, subclause B.
Minimum.
The lessee shall extract and dispatch minimum 60,000 square feet. So, my lord, I'm sorry.
No, it's all right.
Lord, my prayer was rejected, my lord, on 2 scores. One is that you have extracted 60,000. So whether pandemic, no pandemic, whether the order passed by the district magistrate for stop work or no stop work, how are you prejudiced? Second thing is, your lease expired on 8th November. My lord, I have, my lord, satisfied, my lord.
It's 60,000 cubic feet per acre per annum. Per acre per annum.
Yes.
That you have extracted.
That I have extracted.
And if you extract more, you will pay more royalty.
More royalty. And to that effect, my lord, now I take, my lord, to the relevant portion of my pleading, I shall only place one, my lord, paragraph, which is paragraph 30 at page 16. 16.
16, sir.
16. Page 16.
Yes, sir.
But this is paragraph 30. The petitioner submits that during arguments, these facts were brought into the notice of the concerned authority. So far as the contractual obligations on the part of lessee, the petitioner intends to submit. The said clause has been stated in part 7, 3B of the said lease deed. The said clause are extracted. I have just shown to my lord. Therefore, the petitioner have the minimum limit of excavation, the sand 60,000 cubic feet per annum per acre. Petitioner was allotted 10.43 acres of land. So, Lord, this is a computation per year. So, in total 5 years, this is a cubic feet. In this regard, the petitioner submits that there is no such maximum limit of excavation, and the petitioner have excavated the quantity of sand above. The minimum limit upon duly making payment of the royalty says to the state respondent authority, and the authority approved the same. And thereafter, the said quantity of sand has been excavated.
No, maximum limit is there in the environmental matter.
Yes, yes. Now kindly see, my lord, I have referred to the mining plan. The petitioner states that as per mining plan, table 7.1, year-wise production details are given as follows. Then the year-wise production details, my lord, I have provided at page 17. Therefore, then the year-wise production, and then therefore it may be submitted here that as per mining plan, in as much as per the rules, the petitioner could extract sand per year so and so. So in total 5 years, the petitioner could extract sand so and so, whereas the petitioner has only extracted sand so and so. Therefore, petitioner till receivable challan of so and so sand. But I have pleaded paragraph 30 to dispel the ground of 60,000 cubic feet taken by the first authority, the ADMLR, as well as the appellate authority. The 60,000 connotes the minimum quantity, failing which I'll be.
No, so far the page number 17 is concerned, what is the amount of extraction?
Blood the
According to you,
blood the amount of extraction
was only extracted
one
17359,412. It is admitted by them that they have only done it.
बोले दी
हाँ.
हम तो सर हम ही बोलते हैं
कोटी 1 crore 73 lakhs.
Yes.
1 crore 73 lakhs, 59,000 cubic feet.
My lord. And
Is it within that portion that is to be looked into?
EC is to be looked into.
That is also required to be looked into. Within the environmental plan or not?
Look, this is the mining plan. This is an extract of the mining plan of this deed.
No. Environmental clearance.
Yes.
Specifies the maximum limit.
But I say
Whether you have exceeded or not, that is to be considered also.
Lord, first thing is, Lord, it is not the case, Lord, of the appellate authority. This issue has not, my extension has not been declined on that ground. And secondly,
that's true.
And secondly, this, Lord, this what I am showing is a part of my writ petition in annexion as well.
I understand, sir. Paragraph number 30, page number 16.
My lord.
Is denotes the minimum quantity you have to excavate.
Plan page. Yes, my lord.
Am I correct, sir?
My lord.
Because it comes to 31,000, 29,000 cubic feet.
My lord.
Those are to be minimum. Those are the minimum quantity which are to be excavated.
My lord.
Otherwise, you will be subject to penalty.
Penal cost. Penal charges.
Now, according to you, you have extracted in 5 years 1 crore 73,000 or odd.
My lord.
It is to be looked into whether as per the environmental clearance you have exceeded the limit or not. That is also to be looked into, sir.
No doubt about it. Lord, kindly but see that number one, that that I
admit that in the commissioner has not dealt with so.
As of now, I am dealing with the order passed, my lord, against which I have come up before, my lord. First thing. Second thing, my lord, this quantity which I am showing, this bears two things. The approval which I have submitted before the authority, along with the mining plan and the environmental clearance.
No, Mr. Chaudhary, I understood, sir. In paragraph 17, you have categorically indicated the quantum of extraction as made by you.
Yes, well, I have followed.
You have extracted.
My lord.
I am on, because I am dealing with this type of cases.
Followed.
I am also to see,
my lord,
whether this amount exceeds the quantity as envisaged in the environmental plan or not.
My lord. Lord, my environmental.
Have it been in the event if I found sufficient perversity in the order impugned,
my lord,
even then this High Court cannot allow you to excavate
if I am
said that which has been mentioned in the environmental plan.
No doubt. I have followed, Lord. I have followed.
That is the point.
Because mandamus cannot be issued to do something which is not permissible in law.
Absolutely.
No doubt.
That is to be looked into.
My lord. Lord, kindly see page 73.
Yes.
But this is, my lord, the district level environment impact assessment authority. Lord, its report is dated 7th of June 2017. And then
Which clause is relevant, sir?
But I'm only saying, my lord, that the environment clearance is there, and this is, my lord, related to the mining plan. My lord, environmental clearance is, my lord, apropos the mining plan. My mining plan, my lord, is page 31 onwards.
Give me a second, sir.
I'm sorry.
Yes.
But kindly see, this is apropos the mining plan, which starts at page, the relevant of which is at page 47. This is the approved mining plan. And my lord's attention is kindly be drawn, my lord, to 7.2.1, year-wise production. Now, my lord would kindly, my lord, take the trouble of tallying 7.21, 2.1, the production detail table with my pleading at paragraph at page 17. This is the same chart, same figures.
Hmm.
So, my lord, my
Your deficit is 16 lakhs 57,715.
Yes. And
As
this,
per mining plan,
yes,
you were supposed to extract 1 crore 90. You have extracted 1 crore 73. So your deficit is 16 lakhs 57,000.
Right.
That is your case. Let him.
I think we need to come up with the report.
See,
আমি তো কি করবো এই যে
after this long, my lord's valuable time before vacation.
we have not indicated, sir.
we need to come up with the evidence. There are so many calculations, and also I'm sorry,
Would have done, no? Who is your junior advocate? Why have not indicated? See your wastage of time. In your energy, our my energy.
Look, we will get it replenished because Mr. Dhor would take me to his bar association, treat me over a cup of coffee. But my lord will have to wait till 4:30. My concern is that.
No, sir. Apart from that, some other persons are waiting. No?
My lord, that is.
Very unfortunate. If you don't do not keep any liaison with your seniors. At the very outset, that you ought to have said that there is hardly scope to pass any interim order. Let me come back with a report.
My apprehension is.
When will come back with the report, Mr. Thor? I've heard it substantially. Come by next week. Next week, sir.
Give us a 10 days time.
Then vacations, my lord, would come. Vacations. The next week.
Very unfortunate state of affairs.
Next week.
Next week.
Number 15. I am for the petition on the left, but I have been late by Vikas Ranjan Bhattacharya. Malad, he has just now left the court or we are arguing before the election.
After vacation?
No, Malad, it is very urgency, Malad.
Then when?
I said Monday there will be no court, Malad. I think the facilitation of our honorable.
Tell me on which day?
Tuesday. Tuesday too.
On behalf of the writ petition and accommodation has been paid for. Who is for the state?
I am for the petitioner.
Who is for the state?
Mr. Banerjee appears for the state, my lord.
Where is he?
My lord, he is currently.
May we start or give it a passover?
My lord, they shall start, my lord.
Because start, I will not stop.
My lord, I'll inform him.
Before going to the petition.
Who is the junior to Mr. Banerjee?
My lord, Mr. Shivashish Banerjee.
Where is he?
Lord, I do not know about his whereabouts.
Not today.
Well, demolition order, demolition order will be tomorrow, will be taken place. Very short point, very short point. Kindly,
Sir, long short, I don't know. But whether the service has been affected?
Yes, I have given.
Where is the affidavit of service?
Jalapur has received.
Mr. Banerjee is appearing for the state.
Hello.
Service upon the Jila Parishad and the private respondent has been affected.
I have served, Jalapur has received. On the private respondent, I have served, my lord. But today, my lord, the server is down. I could not collect the copy.
When it was sent, sir? 4/9. Secretary has been delivered. It was received. Which order is under challenge?
Before that, my lord, kindly see the High Court's order. On the earlier occasion, page 86.
Impugn order passed by the Secretary Jila Parishad.
Page 86, kindly see the High Court order. On the earlier occasion, writ petition was moved on the ground that this is a PWD land. We are encroaching the PWD land. Therefore, move this writ petition. Kindly see page 86, the order of the High Court.
86. Yes.
Last paragraph, starting from last paragraph.
Yes.
In view of the above, the jurisdictional block land and land force officer, BLRO, upon prior notice to the petitioner and the private respondent, shall cause a physical inspection of the alleged encroachment and construction and shall submit a report before the petitioner, the private respondent, meaning there we are the petitioners. Yeah, just private respondents and the jurisdictional assistant engineer, PWD. This report has not been submitted upon us in terms of the court's order. Second, the exercise shall be carried out and completed by the jurisdictional BLRO positively within a period of 4 weeks from the date of communication of this order. In the event such report confirms the alleged encroachment and construction on the PWD land, then the jurisdictional assistant engineer, PWD, after issuing the prior notice, at least 7 days to the petitioner and the private respondents, and after giving them opportunity of hearing, shall decide this matter, a representation
dated such and such as referred to the above by passing a routine order in accordance with law. Now kindly see, the report of the builder has not been served upon us. Secondly, the jurisdictional assistant engineer has not heard this matter. Notice has been given by the Secretary Jala Parishad. Kindly see, the notice has been given and the order was passed.
Now, in the earlier round of litigation, who is the read petitioner?
The private respondent.
What is his allegation?
Allegation is that we are encroaching the PWD land, and he is, in view of such encroachment, his ingress has been stopped. This is allegation.
So it is a case of West Bengal Highways Act.
Highways Act, 1964.
Then who has passed the order?
Secretary Jala Parishad.
He? The direction of the High Court to that effect.
But direction assistant engineer, I have sworn to your lordship. Jurisdictional assistant engineer. And under section 10(1), you also know that assistant engineer is the authority. How can the Secretary General pass the order? Under which provision?
This order cannot stand.
My lord, I do not have any material instruction, and I am not even empaneled, my lord.
That is why I am asking where is Mr. Banerjee?
Anyway, my lord, we do not have any instructions, my lord. If your lordship directs, you can your lordship can stay this order pending the disposal of the instant.
Don't say that. The affidavit of service has filed today on behalf of the writ petitioner. একটু ঢাকো তো তুমি যে নম্বর
Petitioner before your lordship is the owner of the land. It was inherited from his father. In the LR record of right, it is recorded in my name. PWD roads going to encroach my land and constructs a drain. I made objection. I came before this Honorable High Court. High Court had passed an order directing the executive engineer to take decision. But a decision was taken that the land has already been acquired.
Utilized.
This land.
Land has been acquired or utilized?
Land had been acquired, not utilized. When it is come to utilize, then it is came to my knowledge. Then I made objection. This is my land. It is recorded in my name till date.
Then what happened?
Then second I have come before this court. Court directed the BLRO to measure this matter and direct the executive engineer to inquire and pass a reason order. It was passed a reason order that land has already been acquired. Therefore, I came before your lordship. If it is acquired, then give me my compensation, nothing else. Now, this is the order your lordship will find, the last order they have passed by the BLRO, page 47. And junior engineer, page 45. Now, these two orders have been passed.
But the petitioner's recorded portion in the subject plot has not been affected by the construction works of H2. But the entire plot of land was acquired.
Entire plot land of acquired blood, my portion is only 6 decimal. But it will, page 23, it will find the record.
Yes, Mr. De. According to land was acquired. Okay, টাকা না দিয়ে acquired করেছে এটা কোথায় লেখা আছে?
He has not been given any notice also.
Land was acquired, my lord. According to the provision, acquired means, my lord, must pay the
Acquired means must
Yes,
give
my
the
lord.
give the money.
That is.
First acquisition,
So,
then given money.
then the respond number 5 will decide. Yes, ma'am. Respond number 5 authority will decide. Yes, my lord. Whether money was compensation was disbursed or not. Yes. In acquired portion. Yes, madam.
But he will, whether he will bring the records. Then it will,
No, the land acquisition officers how 24 hours will take a decision. Yes, my lord. Dhiman Banerjee.
I am led by Mr. Sabir Ahmed in this matter.
You are for the petitioner. Very good. Who is for the state?
The other Mr. Oshim Ganguly and Mr. Bilal Sheikh have appeared. Instruction to appear on behalf of the state. I have
Well, Mr. Ganguly.
served them a notice, Lordship.
What is the matter about, sir? Was 10 Highways Act. What happened to him? Give. কি আছে দেখে নি।
The respondents, Lordship, I have sent through.
Take the microphone.
The other respondents, I have sent through the post, but as on date, Lordship, I could gather that it has.
When
not
the
been
notice was served?
On 8th, I have posted.
Today is only 11. The affidavit of service is filed today on
Upon all the respondents except the private respondent, it has been effective.
It was on 28/8.
Lordship.
What is the fate of the service upon the private respondent? As per the affidavit of service?
It has the endorsement, consignment has returned, Lordship. Incomplete address.
Incomplete address. May I see? Don't know the address of your private respondent. এটা তো হবে না। Joyanto Mondol, no such person at this address. You don't know the address?
It is the property which is under dispute is situated in front of my house. I have purchased a property by way of a registered deed of. I have obtained the deed of gift from my mother, a property, and in front of my property, unauthorized construction has been taking place on the state land, PWD land.
Then what happened?
Lordship, we have. May I be permitted to place the case?
Then what happened?
Then, Lordship, we have.
How you are going to be prejudiced?
I am going to be prejudiced, Lordship. As far as the West Bengal Highways Act, Lordship, no unauthorized construction could be carried on over the public land.
How you are going to be affected?
It is situated in front of. If your Lordship may kindly take page.
Mr. Banerjee, try to understand my question. If according to you, private respondent is making an illegal construction over a government land, how you are going to be affected?
I am being affected because, Lordship, my ingress and it is made in front of my
In which paragraph you have stated? In which paragraph you have stated, Mr. Banerjee?
And due to the.
Which paragraph you have stated? May I indicate or you will indicate? Paragraph number 7, last 3 lines. Read.
The said unauthorized construction is causing hindrance to the petitioner from enjoying her right to a free access to her land from the said metal road.
That is so simple, sir. We have to do, we have to,
But apart from that,
we have to
Lordship,
inculcate so that our legal equipment and eyes can be there. Listen to my order. Take down.
Your Lordship,
Don't get nervous. How long you are practicing, sir? How long you are
from
practicing?
22.
22. Very good.
Only
Listen
one
to my
thing,
order.
Lordship, only one thing, Lordship, may I just beseech, if your Lordship may kindly call for a report regarding the approachment part.
Very good, sir. Listen to my order. Number 19. I'm getting put now.
I put the respondent number 7.
Question is a biggest purchase here. Can I have it? Monday. 2021 Monday. That will be the same petition minus.
Yes. Monday to first have only court.
Now, however,
Sir, ঠিক আছে।
I appeared that was the first case. I found is really brilliant man. This fortune. No, somebody come up with this like the may leave now, man. May leave.
রিপোর্ট দিয়েছে।
Alan, I'm happy for the.
হ্যাঁ 2021 মানডে করে দাও হ্যাঁ
তো ইনোকুয়াস প্রেয়ার সব আপনি কি অবস্থা পার্টিসিপেট করুন
Ladino cost fair before your lordship, page 95 is the letter issued by the.
Certainly.
I have for as because my lord is in the hospital only otherwise my lord. Yes sir. Yes some support from the court.
Lordship.
How this the future of
Lordship. Hand over Kuru.
Is there any private respondent, madam?
Yes, my lord. I am for the appearing for the private respondent 7 and 8.
7 and 8.
8.
Page 95 is the letter.
Give me a second, ma'am. Yes, madam.
Page 95 is the letter which issued by the prescribed authority.
Page 95.
Yes.
Protection of record of rights, no? Proceeding to
It is absolutely illegible, sir, madam. Final order of Ilar appeal case number.
Yes, final order will be passed by the prescribed authority on 19th/8/2025 without hearing me. I file written objection on that, my lord, appeal. That was, my lord, 107 onwards. That written objection I already filed, and that was already deposited before the authority concerned. Without hearing my written objection, my application straight away, my lord, final for declaring the final order.
You are party to the appeal?
No, I am the affected party. My property will going to, my lord, going to mutate in others' name. And whose name this was made,
No, my
they already filed one title suit. There was an injunction. I annexed everything. And
you are not a party to the appeal.
No,
Who is the appellant?
appellant, my lord, the private respondent hearing, the appellant.
Against the order of?
Against the order passed by the BLLRO.
What order has been passed by the BLLRO?
BLLRO, my lord, corrected the record in favor of other person.
Then how you are interested party?
Because there is a co-sharer of the property. My lord, I am the co-sharer of that property. My grandmother was the co-sharer of the property by legal inheritance. I am the.
So you are a necessary and proper party.
For that reason, I made application before the.
Where is your application?
Page 107 onwards. Page 107, annexing all the documents. There is my legal inheritance. They file already title suit.
Where is your page number?
Page 107, my lord. and I annex everything, the title suit, which the private respondent filed. They
So you want to intervene?
Yes, my lord, my prayer may only before your lordship to hear my written objection at first, then final order, any order that passed by the prescribed authority.
Conscience, my lord, says that I should not stand in the way.
Absolutely.
Because 107, she has filed a written objection. And next
When,
date
when
is
the order is going to be passed?
on 19 September is the next date fixed.
For final order.
No pending.
What have you got to say?
I have no knowledge about this application.
Very good. Take down.
Only one with a
I
rider.
filed the appeal.
With only one rider. Kindly see the address of this lady petitioner. She's from Gujarat.
Yes.
So she should not take adjournment after adjournment. I can't come. This and that. Lordship, kindly take care of this so that proceeding is not.
This writ petitioner is a person of Gujarat.
Yes, kindly she has said, I'm from Ahmedabad.
So as representative will
So that it is not lingered. So she kindly take care.
the affidavit of services
Kindly take it up tomorrow. Only 1 minute is left.
1 minute, 1 minute enough. I think 1 minute enough for this matter. Yes. Your lordship, kindly, 1 minute enough.
I am for the petitioner, my lord. I'll
Oh,
take
yes.
few minutes to show.
Very good, sir.
My lord. My lord. Similar to this matter, just previous matter.
I have no difficulty, lordship.
Place several things.